right, good morning. I see Ms. McLean is present, representing Ms. Janet Stout. Come on up, please, sir. And I see also Ms. Janet Stout is on the line.
Yes, Your Honor, I'm here.
Okay. All right, we're here this morning on Ms. Stout's motion for contempt. So I've read the pleading, so I'll hear from the party. So I'll first hear from Ms. McLean, who represents Ms. Stout, and then from Ms. Ernest, who represents Mr. Stout.
Thank you very much, Your Honor. So on behalf of the petitioner, Janet Stout, we are asking for a finding of contempt against Mr. Stout for his non-compliance with the court orders. You had ordered that he was to pay $2,250 per month in spousal support effective August of 2023. He paid $1,900 for both August and September of 2023, and he currently owes my client $700 for the shortage plus accrued interest. We did forward correspondence to Mr. Stout advising him of these issues. He never responded back to those issues that were raised. He never provided the additional payments. It's also notable that he had received, I believe it's about $33,000 in September from the monies that were being held in my trust account. It was $33,129. He only deposited $28,129, so he must have reserved $5,000 in cash. He never has disclosed the whereabouts of those cash or of the cash. And the assumption is that those were clearly available to him at the time where he could have brought his spousal support current. In addition, the court ordered that he was to pay my client 50% of the FERS pension, and that's 50% of the gross. And that equates to $1,155 per month. And he's to provide payment to Ms. Stout directly until OPM administers the court-ordered, administers the COPE, where they end up providing those payments to her directly. So he failed to pay for August and September at the $1,155 per month. And so he currently owes her $2,310 for those 2 months on the first pension plus accrued interest. The court also, and Your Honor was the one who heard this matter at the time of trial. Mr. Stout had offered to continue and indicated that he had the financial wherewithal to continue to provide the health insurance for Ms. Stout through the federal government. That is an option for her to be able to continue to be covered by the insurance. She provided to you in her responsive documentation verification of the communications and the forms that she provided to OPM within the time frame. She had 60 days to do that, and she provided that information to them. She has never heard back from them. Obviously, there is some frustration with the federal government at times and how slowly those wheels at times work. But at this point, she's had to secure her own health insurance coverage, of which we forwarded that information to Mr. Stout, and he has not provided payment for her health insurance costs, which clearly is an order of the court. Finally, in regards to the life insurance, the court did order that he was to continue to cover my client on the life insurance policy. The amount was $95,000. I note that in his reply documentation, he indicates that there's a decreasing level to that insurance policy. I'm not aware of that. There hasn't been any documentation provided to support that claim. So we're asking that the court order that he comply with providing the documentation verifying that he has reaffirmed her as the recipient or the beneficiary on that policy for that to continue. I have provided to the court a proposed contempt hearing order. So we are asking that the court provide judgments of the past due spousal support of $700 plus $54.66 in accrued interest. For the unpaid first pension of $2,310 plus $180.37 in accrued interest. For the delinquent health care insurance costs of $761.54 plus $21.16 in interest. We're also asking that the court order civil penalties of $300 and attorney's fees of $2,000. I note that Mr. Stout, in his response, suggests that he doesn't have sufficient income. We've provided information and documentation to the court. My client outlines for you that his bank statements show that he's pulled $8,000 in cash withdrawals from his bank accounts. That means that he's had an average of $1,142 per month of additional cash that we have no idea what he's done with, as well as that $5,000 that I talked about at the commencement of this case. Obviously, he's made some discretionary choices on how he wants to spend the property award that he received. My client currently does not have sufficient funds in order to meet her own dental needs. She thinks that it was exorbitant as far as his choice in light of his financial obligations. So we are asking for a finding of contempt. We're asking that the court grant the judgments as requested. We're also asking that the court provide that he is to sign appropriate documentation so that monies are automatically withdrawn in the future so that we don't have to worry about consistency on payments.
Thank you. All right, Ms. Ernest.
Thank you, Your Honor. I want to start off by saying that my client, he's 71 years old and he does have some struggles cognitively. We provided some documentation to the court to that fact, mainly a study that was done, I believe, either before, around the same time that the divorce was finalized or that the trial happened. I'm appointed solely for the contempt issue.
I got it now.
Sorry.
I am appointed solely for the contempt issue. Mr. Stout has navigated this process. It's a complicated process for the vast majority of this case by himself. The final resolution of this divorce has been confusing and frankly overwhelming, and he hasn't had really a lot of assistance in understanding the orders. Any failure to comply with the court orders on my client's part has not been willful. There has been a lot of confusion, and I want to break that down. So when it comes to the spousal maintenance, my client believed after the correspondence of the court and the final orders that his obligation of $2,250 was to begin in October, not August. He didn't read in the correspondence that it was supposed to begin in August. And when the September 7th correspondence came out, he had already paid his $1,900 temporary spousal maintenance. He didn't know about the reconsideration process, and he again, really struggled to understand the full impact of the correspondence and the order. When it comes to health insurance, his belief was that at trial, he agreed to pay for September and August's premiums because of Janet's upcoming surgeries. He says that he didn't intend to agree to pay indefinitely. Again, didn't know about the reconsideration process, didn't know how to challenge that in the final orders. He hasn't really had any part in whether or not she's able to stay on federal health insurance. Her insurance benefits were basically automatically terminated when the divorce was final. Mr. Stout here did have a call with OPM to try to take care of whatever he needed to for the health insurance premiums. And they basically told him that if he tried to keep her on there, that he would be liable for a fine and potentially prison. Based on that conversation, he's been operating under the belief that the court actually overstepped. I think there needs to be some clarification in that today. When it comes to life insurance, his understanding at trial and with the court orders was that he was supposed to maintain the status quo. He has not changed anything in his life insurance policy since he retired several years ago. It was already in a cascading downward sort of situation, which is what it currently still is. But again, he hasn't made any changes to it since he retired. He thought it was just supposed to be status quo.
So
the biggest issue here,
can
however,
I ask you a question on that? Is there so your Mr. Stout's representation is that he has not removed Ms. Stout from the life insurance policy as a beneficiary?
she's still on the life insurance policy. He's not removed her from the life insurance policy. The question is, I think, the amount of the life insurance policy at this point.
Okay, I think the representation, at least from Ms. Stout, was that she's no longer the beneficiary, period.
No, he hasn't made any changes. She's still on there.
Okay.
The biggest issue, however, is Mr. Stout's ability to pay. He currently pays Janet more than 50% of his income every month. The bank statements show that the money that Mr. Stout actually gets deposited is around $6,566. After his rent obligation and the $3,405 that he pays to Janet, that leaves him $21 for gas, insurance, phone, medical related costs. Where he's currently living, which he has to leave because he can no longer afford it, does pay for utilities and meals and things like that. So he hasn't had to have those expenses. But even with that, $21 for gas, insurance, phone, et cetera, is simply just not enough. He's living in a deficit at this point.
You indicated that he's moving at the end of May. Is he moving to a lower cost area or housing?
The last I spoke with him, he was unsure of where he was going to be living. He doesn't really have the resources, as you can tell from his bank statements, to really go anywhere else at this point. His representation to me is that he currently believes he's going to have to live in his car. I don't know if he's going to have another option. I think that's still up in the air.
If he's paying $3,400 a month now for housing, why would he have to live in his car?
If the court is going to order that he also reimburse her for the medical benefits and continue to pay the amount that he's currently paying, he's going to have, I think, less than $3,000 to pay for housing, food, transportation, medical bills, all those things. And it's simply, he's going to have some money, but it's not going to be enough. $3,000 for assisted living is actually a pretty reasonable amount that he currently can't continue to pay. As for the mystery $5,000 that went missing from the lump sum that he received, Mr. Stout used that money to pay for help moving out of the marital home. It cost him money. He's 71 years old. He can't move all that stuff on his own. He did hire help to do that, and recruited help to do that, and was able to pay them with that. That's where that money went. It's not went on frivolous spending or anything like that. He did receive $30,000. The money is gone, and it was not discretionary spending. He had already began the dental treatments before the divorce was finalized. A lot of that money had already been billed before the divorce was finalized. He does not have dental insurance, and so it wasn't covered. He is really trying to do the best that he can, make it work with what he has, but he does not have enough money. Another issue that really contributes to this is the amount of the 50% of the first pension that he is ordered to pay. He really only receives about $1,300 of that every month. And the gross is $2,300, but the amount that he receives is $1,300. And a lot of that $1,000 that is missing from that equation goes to his own health benefits and federal taxes. Those aren't really discretionary spending items either. They're necessities. And if what the court is currently ordering is that he pay all but $126 of what he actually receives from FERS every month. All this is to say is that the current order and the situation that we're in leaves Mr. Stout with extremely limited funds. He does not have the ability to pay. He did receive that money. Mrs. Stout received it twice, if not 3 times more, as much as he did in the overall settlement. He cannot sustain this level of support without it bankrupting him. He understands that he owes 50% of the FERS pension to Janet. He's not trying to skirt obligations, but he's simply just doesn't have the funds to do what the court is asking him to do. Again, none of these actions have been willful. A lot of it has been confusion driven. A lot of it has been simply not being able to afford certain things. And for that, we're asking the court to not find him in contempt and give him another chance to comply, perhaps with some further clarification from the court about what his obligations are.
Thank you, Ms. Ernest. Ms. McLean, any rebuttal?
Yes. First off, in regards to the argument that he had to use $5,000 from the $33,000 of property division that he received because he had to move out of the home. He had already moved out of the home a year prior. The home closed. The home sale closed on November 10th of 2022. He was already living in Olympia, so there was nobody to pay to help move items from the home. That had already occurred a year ago. So I'm confused by that argument. I'm also confused by the representation about his concern that he needed to inform the federal government that they were divorced or he was going to be fined. What that does is that tells the federal government they're divorced. She's going to come off of the health insurance. She still has the ability and did submit her documentation to OPM in order to maintain her insurance. What that should have done would have been to reduce what he was paying if she's been removed from his insurance. We've received no financial documentation as far as what he receives on a monthly benefit from FERS at this juncture, which clearly is available to him as far as his gross and what that breakdown is. At the time of the trial, the deduction for their joint health insurance was $589.23 per month. So if she's been removed, that amount has been reduced, which means his net should have been increased. But if he's also told them that they're divorced, then that also triggers that she's no longer a valid beneficiary, because under divorce law, once you divorce, you would have to take affirmative action to reclaim her, reappoint her as the beneficiary on the insurance. We've asked him to do that. We've never received proof that he's done that. So the suggestion that she still remains on the insurance, in order for that to be viable, he has to provide a new beneficiary request to the government, re-identifying her, because otherwise they consider her an ex-spouse, and that isn't a valid beneficiary status. In regards to his claims about, his suggestion that he's going to have to live in his car, as we outlined, he is a disabled veteran. He has veteran housing available to him.
Objection. I believe that's speculation. We don't have any information about whether he would actually qualify for that. I think that's an oversimplification of VA benefits in general. It's a lengthy process to apply it.
The objection is noted, and I'll allow a little leeway in the matter. Go ahead.
He also, being a disabled veteran, has medical and dental care available to him, such that he wouldn't have any out-of-pocket expense.
Basis.
Objection, the same rationale. We don't actually know. Just because he's a disabled veteran does not automatically mean that he qualifies for veteran assistance, medical and dental. There's a lengthy process that we don't know if he would qualify for or not. It depends on the disabilities, when the disability was sustained, was it in action, was it not? I just think we don't have enough information for that.
So if you're a veteran, you're not entitled to medical benefits?
Excuse me. I am available for medical, but then if it's not covered, it falls back on my insurance. Dental is only available to Purple Heart prisoners of war that have had documented dental problems due to service connected, and that is all that is available for dental. I am not available at all for dental. And
Okay, I appreciate that input. The objection's overruled. You can continue, Ms. McLean.
We've also, in my client's declaration, outlined that he does have family that's available where he could live with them until he were able to qualify for other housing that he perceives as affordable. But again, he has not explained at all these cash withdrawals from his accounts that are averaging over $1,000 a month, which clearly shows he could have paid my client. He's in this situation because he didn't follow through with the letter that I had sent to him outlining the court's ruling. He didn't follow through with the court's ruling. He had $33,000. He could have spent, a couple $100 on a consultation with an attorney if he had questions and concerns. So we're asking that the court find that he has willfully violated the court orders. I would also note that this suggestion about confusion and the evaluation that was submitted, clearly he needs to make sure that he takes his medications appropriately. He's provided no documentation that he's followed through with any of those recommendations. And again, that's his obligation and responsibility. So we do believe that a contempt finding should be entered.
All right, thank you. All right, I took a moment to just look over the letter ruling that I issued to the parties back on September 7th of 2023, where it at least in my mind, it seems fairly clear what the court's findings are and what the obligations are of Mr. Stout related to the findings the court made at the trial. So going back to the maintenance, the court made a decision that the total gross income that Mr. Stout has is $7,589, so just shy of $7,600 per month. So there's a sizable amount there that was divisible, which the court did in fact divide with the pension and with the maintenance payment. So Mr. Stout indicates that he's suffering from a mild degenerative mental decline. And I guess that's not to be it's not unexpected that when people get to certain ages, there are declines. But there's nothing showing that there was anything confusing about the letter order or the letter ruling or the like. There's claims of not aware of the reconsideration process. A person who's representing themselves may not know of that process. That makes it difficult. I recognize that. And then if there's a mild degenerative decline, that makes it more challenging also. Nonetheless, there are resources for individuals who are needing assistance, especially when it's more kind of an understanding of a court's ruling as opposed to full representation. It's very much more limited in scope. So there was concerns that he was not aware that the order started on a particular date, and that's why he underpaid. The letter ruling makes it very clear of when the date the payments are due. So as far as the maintenance shortfall for August and September, I'll find that there was a willful contempt there for the underpayment of the $700 for the combined 2 months. Regarding the FERS payments, the pension payments, there was the August and September where there was no payment made, which was the amount of $1,155 times 2. So I'll make a finding that there was contemptuous activity there by not paying those monies. As far as the life insurance, by virtue of the divorce, it sounds like Ms. Stout was removed from the policy. The court ordered that she needed to remain as the beneficiary. So Mr. Stout will need to make sure that she's reinstated and get her as the beneficiary on that life insurance policy. As far as the health insurance, the indication was that from the letter ruling that Mr. Stout was to keep Ms. Stout on the on the health insurance policy. He failed to do so, and as a result, Ms. Stout needed to provide coverage because she has her own health issues. So that was $761. I'll find that was willful also. I'll impose the $2,000 of attorney fees, and I'll impose a $100 fine. So I'm just going to make an amendment to the order, changing the 300 to 100.
That will also need to be changed at paragraph 8.
Right.
And then does the court want to schedule a review hearing?
And what would the purpose of the review hearing be? To make sure that the insurance beneficiary has been reinstated?
Well, and then the question is, as far as reimbursement, so is the court adopting that he's to reimburse her within 10 days as outlined in paragraph 11?
Paragraph 11, as far as
page 4.
the purging, is that what you're talking about?
Yes.
Your Honor, I'm going to have to ask if we can come up with some other type of arrangement. His bank statements have been provided. He does not have this money, especially to pay in a lump within 10 days. He has been living in a deficit. He doesn't have the money to do it. He won't be able to pay it.
If it was instead of 10 days, if it was 30 days, would that be of assistance?
With his limited income and continued obligations for the money that the spousal maintenance that he owes Janet, I don't think that 30 days would be enough either. We're going to need significantly more time than that.
2 months?
What is the total amount that we're looking at?
So I think maybe Ms. McLean has it added up, but if I take a look at the table, it's 3,037, 57, about 5,800.
I have $6,127.73.
Okay, so it's in the $6,000 range.
Considering that after his financial obligation to Janet each month, he only has about $3,000 left. I would have to ask for like a year for him to be able to pay this in full.
I'll change
think
it
in
to
the past-
45 days. On paragraph 11, it'll be, need to be paid within 45 days for the purge to take effect.
So you're changing that to both paragraphs A and B?
Yes,
Okay. So no review hearing at paragraph 12? Originally, we were scheduled for a couple weeks ago. That's why we have today's date on there.
right. I'm taking a look at the calendar. I'm looking at a possible review in 2 months because that's roughly 2 weeks after the 45-day period, which would allow documents to be obtained to make sure everything's been paid. Did you say the 10th?
Yes, July 10.
Yeah, that sounds fine. Ms. Ernest, I recognize that your representation may end today or may extend. I'm not exactly sure. But how does that look for your schedule? And if you're not involved, then I'll just ask Mr. Stout directly.
I'm appointed solely for the contempt issue, and I think that continues to be part of the contempt issue. I'm happy to stay in for the purpose of the review hearing on July 10th, and that would work for me.
Okay, so we'll set the review for July 10th at 9 a.m. I've signed off on that order. Any additional questions or clarifications?
Yes, sir. Yes. Why were?
All right, that'll conclude the hearing. Thank you.
Thank you. I'll provide counsel with a conformed copy of the order once it gets
Somebody
out.
Brody's on the line. Okay, all right, thank you.
I'm here.
Okay, welcome to you, Ms. Brody. Can you turn your camera on, please?
1 minute, sorry.
Let's see. Did you say you're going to try to turn it on? Did you say?
Yes, I am trying to. Sorry, my
Okay.
phone was completely dead. I just got it on.
Okay, thanks. And is Ivan Molina on the line today?
Yes, Your Honor, I'm here.
Okay, welcome, Mr. Molina. And then Ms. Height is here, the guardian ad litem. She's present.
Yes, Your
Good.
Honor.
All right, just going to take a moment to pull up my notes. We're here on Ms. Brody's motion related to a restraining order and also a temporary order that's related to that. We were here not too long ago, and so there were some allegations related to the child's well-being, bruising, neglect related to food, and that there was a temporary restraining order that was imposed back in February that prohibited Mr. Molina from taking the child out of Washington and not assaulting mother or child, and that the child would remain with the mother until the hearing. There was additional information that on April 3rd that the court allowed additional visitation for the father over a couple of different weekends during April. And there was to be a response served by Mr. Molina by a certain date. He submitted that, and that was on April 11th, and I reviewed that. So we're here today, and I just was, maybe we could start off with just input from Ms. Height, if you've learned anything recently that you'd like to share with the court.
Thank you, Your Honor. I am disappointed to report to you that I have very little to report to you. I was reappointed. I sent packets out on April 7th. Have not received anything back. I have had several phone contacts with Mr. Molina. I contacted 9 different phone numbers trying to reach Miss Brody. I finally did get a call back from her when someone contacted her on my behalf, and she said that she was unable to meet with me presently because she is in the process of moving again. I was unable to meet with the daughter because she does not appear to be in school anywhere. She's 7 years old, not in school. So essentially, I have had no contact that is going to be helpful for the court as far as how this child is doing. I would also let Your Honor know that in my contacts with Mr. Molina, on April the 12th, he had come down for his court-ordered visit. He comes down from Island County, and he had driven down, I believe it's about 5.5 hours, and contacted me and said he didn't have any contact with the child. Mom wasn't returning calls. And so he waited a while and went back home without the child. She essentially withheld him. I don't know what the situation was, but she would not respond to any contact from him. So he has not, to my knowledge, had contact with this little gal either. So all that to say, I have very little specific information as far as the well-being of the child at this time.
Okay, all right, thank you, Ms. Height. Let me just double check with Ms. Brody. Ms. Brody, were you able to get your camera on? Okay, so Ms. Brody, a question for you. Last time we were here, you were in front of Judge Scudder, and Judge Scudder ordered that the father have visitation on 2 weekends, on the 12th through the 14th of April, and then the 26th through the 28th of April. Did those visits happen? You're on mute.
Can you hear me?
Yes.
I had made contact with Ivan prior to said visit the day before, giving him well enough time to know that he shouldn't be coming down because my child was hospitalized. We had been to the hospital, and my daughter was referred from the hospital, which I submitted to the courts. She is referred to trauma and abuse counseling, so she's actually active with that.
So
And
is
she's
your representation, Ms. Brody, that the child was in the hospital on April 12th?
I have I don't remember the representation.
Is that what you're saying? Is it you're saying that on April 12th the child was in the hospital?
I'm saying before that, when she found out she had to go with her dad, it went backwards completely. She started her nose, like I have pictures and everything I've submitted. We went to the court or went to the hospital. She's getting nosebleeds, like bad flooding. She's waiting to bed. She gets in hysteria crying. She's saying that she doesn't want to go with her dad. She's night terrors. I can't get her to sleep through the night.
So
She's
on April 12th, when the court ordered the visitation with the child and the father to occur, why did that not occur?
because it was my daughter was physically and mentally unable to go. It was not in the best interest of my child to go. The hospital even said,
did a medical professional make that recommendation or state
The
that she
medical-
should not go?
the medical profession said it's clear that she needs to go see a specialist. So they gave me they referred me to an office. They said that she needs to be with me.
So I'm concerned, Ms. Brody, when a court orders that a child have visitation with a parent, and then another parent unilaterally decides that that child's not going to have a visitation with a parent, that's highly concerning to the court.
I'm sorry. I just I did not want my daughter to be worse off. She's mentally messed up over this man, and she can't sleep. And I was scared for her well-being. And that judge that sat in should have been a conflict of interest because he's been my attorney for, I don't know, quite a few years. And
So the remedies I'm looking at, Ms. Brody, when somebody doesn't comply with a court order, there's a strong possibility that the custody of the child changes dramatically, because if you can't follow one order for a weekend visit and there's withholding of that, there's one clear way to remedy that. So you can tell me if you're gonna abide by the court's orders or not.
I can abide by them, but can we just revisit the visitation circumstances, because this is an abuse and neglect case, and she's supposed to be taken away all the way across, with her dad, and she is scared.
Where's the child enrolled in school?
V prep.
Where?
V prep.
One more time. I can't hear the first part of it.
It's V prep. It's online.
V prep.
Mm-hmm.
Okay. So virtual preparatory something.
Mm-hmm.
And do you have paperwork of enrollment related to that?
I do. It's online.
Right. But as far as enrollment paperwork shows that she's enrolled.
Yes.
Okay. When did that occur?
I don't know specific dates, but it was shortly. She's been going for a few months now. I know they had a hiccup with they were putting her in for kindergarten, and she's supposed to be in first grade or whatever, so they had her doing kindergarten work for a minute, but I don't know the dates. I can get them submitted to you. That's been a couple months now. I'm sorry.
Have you had any contact with Ms. Height? And there's information that she acts as the kind of the eyes and ears of the court and serves the best interest of the child. And so there's information that she needs, which she needs to be able to speak with you.
Okay.
When is your first availability to meet with Ms. Height?
I can meet with her this week or next week. She's in the middle of moving right now.
Okay.
And my daughter's been in and out of the hospital.
Have you submitted any of those hospital records to Ms. Height?
I did when I submitted my restraining order. I did.
Any since the restraining order?
I haven't, but I can get them into the courts. I've been under the weather.
So Ms. Brody, just so you're, from my perspective, what I'm seeing and what the difficulty is that apparently you have information that you've shared with no one else related to this case. The information should have been shared either with the court directly or with Ms. Height, and that has not happened. The other concern is that the court ordered visitation to occur, and that did not happen. So those are from the court's perspective, those are two fairly serious issues. So I'm going to pause there and then just turn the time to Mr. Molina. Mr. Molina, on the 12th of April, did you have a visit with the child?
No, I did not, Your Honor.
What about on the 26th through the 28th?
No, I did not.
Okay. And what's as far as you meeting with Ms. Height and giving her information and allowing her to do her investigation, what's your availability to meet with her?
I was planning on, anytime I go down there to pick up my daughter, if she's available, I can be more than willing to meet up with her then. Just as she said earlier, it's a fairly long drive from where I'm at. Whether that or we could do phone meetings or Zoom hearings like we are now, I mean, I'm available. If you give me a date, I'll be there. And I just want to state from an earlier, so I had enrollment papers stating that my daughter was already in first grade. So it's going back to kindergarten is a little concerning to me as well. I don't know if you've seen that in the paperwork or not, but she was enrolled all the way from the time that I got her back in 2022 to where she was officially unenrolled because she had been out of school for a amount of days for Christmas break. And then after, including in January, so they had no choice but to unenroll her because she had not been attending school. Also don't know where that stands at and what's going on because, as I've said before, I haven't even got to talk to my daughter over the phone, FaceTime, nothing. When it comes to communication between me and Ms. Brody, it's very subtle. The only 2 times that she's contacted me was to tell me that, obviously to say that my daughter was too scared to come see me, which I don't, honestly, I have a hard time believing that because when my daughter has been with me, it's been nothing but good times. And so it concerns me to wonder what's going on or what's being said or how things are being acted upon over there towards, me. Is she being fed stuff about her father? Because there's no reason for her to be scared of me. There's no reason for her to be freaking out. There's no reason. I mean, I can submit, if I have to, I can submit multiple pictures and videos and just all the good times that we have had together. And I mean, just from those simple things being said, in my eyes, it's crazy to me to think that my daughter's that scared to me that she's got to be admitted to any type of hospital or she's waiting to
No.
because when she was with me.
So I apologize, Mr. Molina. Just let me interrupt. There's somebody else just is on the Zoom call and they need to mute. So anybody that's not directly on this call or on this case, I need you to make sure you're muted. That means you press the microphone icon to mute, and then if you're dialing in with the phone number, you'll need to press *6. Go ahead, Mr. Molina. Sorry for the interruption.
No worries. I just, as a father, I'm concerned for the well-being of my child and the fact that, I'm abiding by all the court rules, and it just seems to be like I'm getting nowhere, not even a simple phone call.
Okay.
I haven't talked to my daughter since December 13th of last year.
So let me thank you for your input. Let me just touch base with Ms. Height. I'm contemplating requiring the parties to speak with you and fully comply with all of your requests during this week and next, and having that completed by the 14th of May. And I don't want to impose that upon you if you don't have time, but I just wanted to check with your time. In the coming week, would you have time to meet with both parties, whether it's in person or via remote means?
Yes, Your Honor, I would.
Okay. All right. So Ms. Brody and Mr. Molina, I'm ordering both of you to meet with and speak with and fully comply with all the requests of Ms. Height by no later than May 14th at 7 p.m. That'll be the cutoff. And so you both need to meet with them and meet with her and comply with everything that she asks you to supply or do. And then we'll come back here next week on the 15th of May at 9 o'clock in the morning to make sure that you've done that. In addition, there'll be a visit this weekend on the 17th of May until the 19th of May, as outlined previously as to what is to occur. So I want to just speak to Ms. Brody. Ms. Brody, May 17th, there's going to be a visitation. I want to ask you now if you're going to comply with the court's order.
Yeah, I'm gonna comply with the court's order. I'm just concerned about the unsupervised and this is a abuse case and trauma. This little girl.
Okay,
You know,
and then, Mr. Molina, are you available this weekend for a visit with the daughter?
Yes, Your Honor.
Your Honor, if I might,
Go ahead, Ms. Height.
you mentioned this weekend.
I did.
Did you mean the 10th and 11th rather than the 17th and the 18th?
Yeah, it's May 8th today, isn't it? Yeah, thanks. Yeah, that was my intent. Thanks for catching that. Yeah, so not the 17th, pardon me. It would be the 10th, pardon me, the May 10th through the 12th. So let me just clarify. Thank you.
Right now.
Ms. Brody, will that work out for you?
So she's going out of town with him to on Friday. What you're saying?
So the visit, as it was contemplated previously in the court order, is that Mr. Molina would drive from Oak Harbor, Island County, down here for the visit, take the child for that period of time, and wherever he was going to be during that time, that's where he'd be.
Okay. Do I get to be in contact with her during this weekend or no?
So
Is that the car one?
Ms. Krieger, you need to mute your phone, Ms. Krieger.
I don't know.
Ms. Krieger, you need to mute your phone. Sorry. So just with the correction of the date, Mr. Molina, this weekend, pardon me, is May 10th through the 12th. Are you available for visitation during that time?
Yes, Your Honor. And I'm just curious, will it still be the same set time as it was previous? Will it be at 5 o'clock?
Right. I'm just going back to that court order from April 4th. I think that's where it's at. So the exchange location will be at the Hall of Justice, and Mr. Molina is restricted from removing the child from the state, has to stay within the state of Washington. So 5 p.m. May 10th will be the exchange. And then on the 12th at 5 p.m. will be the exchange.
Okay. Thank you, Your Honor.
We'll be back
So
here,
do
both
I
parties.
get to be in contact with her?
So I think it's reasonable to have, if a child wants to call and contact the other parent while they're on a visit with the other parent, that's fine. I think one time per day would be reasonable.
Okay.
So
Thank
we'll
you.
be back here next week. Both of you will be meeting with and conversing and fully complying with Ms. Heights. Is there any question from either party about that requirement?
No, Your Honor.
Mr. Molina?
No, Your Honor.
We'll see everybody next week. Thank you.
Your Honor, might I ask one quick question?
Sure.
I typically don't, without the court's order, ask for any kind of drug or alcohol testing without the court's order, but I wonder if, given the short timeline, if I perceive that might be helpful for the court, if I could go ahead and request that, and that would be all right with the court.
Yeah, definitely. The court orders that and grants that authority. So if Ms. Height requests either Mr. Molina or Ms. Brody to submit to a urinalysis or blood test or hair test, then you're both required to do so.
Thank you, Your Honor.
And in addition to submitting to the test, then you're also ordered to sign releases of information so Ms. Height can have that information. So that's really important. So if she requests that, then you need to submit to that and also sign releases of information. Sometimes they call them ROIs.
Thank you very much, Your Honor. I appreciate that.
Any question, Ms. Brody or Mr. Molina?
No, sir.
No, Your Honor.
Okay, we'll see everybody next week. Thank you. Appreciate your compliance. Gilmore represents Jacob Dooley.
Thank you.
And I'll ask if Kiana Morris is present. Kiana Morris, if you're here, please unmute and state your name.
Yes, Kiana Dooley.
Okay, welcome. And I see that Ms. Corey is here, the guardian ad litem. She's present. And give me just one moment. Ms. Gilmore, you indicated that I think you had a request.
Yes, Your Honor. I entered my notice of appearance yesterday. I will be asking for a continuance. It wasn't necessarily clear from the record what the basis of the motion we were before the court on, so I was going to inquire about that. But regardless, I did receive some materials through my client that was submitted by the other party on Friday, and I will need the opportunity to present materials on behalf of my client and respond.
Okay, so I think there's one, I think, Ms. Morris, you're asking for a motion to waive the guardian ad litem fee. I think that's one of your motions, correct?
Yes.
Okay, and then another motion relates to a parenting plan, if I'm not mistaken. Is that accurate?
Yes, I believe it was supposed to be the parenting plan and child support along with a guardian ad litem waiver fee.
Okay. All right. So I think that's my notes kind of reflect that. There was some income financial information that Ms. Morris provided, and also some proposals related to custody and the parenting plan. So Ms. Gilmore is asking for a continuance of roughly 2 weeks. Is that correct? Ms. Gilmore?
Yes, Your Honor, that would be sufficient.
Okay, so that would put us to so that would be the 22nd. And let me check with Ms. Morris if we were to continue the matter to that date on the 22nd of May, would you be available?
Yes, I am also trying to seek out consultation too, or representation.
And
Okay.
if she needs more time, I'd be happy to set it over. I know that there's difficulty. My client had difficulty finding an attorney as well. 3 weeks would be fine. We could also set it on the attorney docket, whatever the court would prefer.
Okay, thanks. Ms. Morris, do you have any input on that as far as a longer period of time? Because I think there's a recognition that their attorneys are in short supply and it's difficult to get in to see them and get them retained.
Yeah, I'm good with the 3 weeks.
Okay. So if we look at 3 weeks, that would put us to the 28th, and it would be on one of the attorney dockets. And I'll turn to the Madam Clerk if she can give me assistance on if it'd be the 9 or the 1 docket. 1 p.m. 1 o'clock. Okay. So would the parties be available to come back on May 28th at 1 p.m.?
Yes, Your Honor.
Okay. Ms. Morris, does that work for you?
Yes.
And Ms. Corey, does
Honor.
it work for you?
I don't, are you hearing me?
I am. There's a small child with Ms. Morris that's
Oh, okay.
speaking.
I am actually not available on the 28th. I'm going to be out of town that week.
Oh, okay. Maybe we could bump it to the 4th of June.
That's fine. That works for me.
Okay. Ms. Morris?
Yes, that works.
Okay.
Also, Your Honor,
Yes.
I have not, I realize that Ms. Morris is asking for county pay, but I have also not received any payment as of yet from Mr. Dooley.
Okay. Ms. Gilmore, do you want to address that briefly?
Yes, I'll speak with my client. I'll coordinate with you on what's going on with that once I have a more understanding of the case.
Okay, thank you.
Okay. All right. So we will set this over for the motion on June 4th at 1 p.m. and we'll hear from the parties then.
Thank you.
Any questions, Ms. Morris?
Nope, that's it. Thank you.
Okay, we'll see everybody then. Are you on the line today? Thank you, Ms. Corey.
Yes.
Okay, welcome to you, Ms. Vaughn. And Zachary Kayoshi, are you present?
Yes, Your Honor.
Okay.
Beth Fellows, the GAL is present as well.
All right, thank you, Ms. Fellows. Like that. Let me just take a moment. Okay, so we're here for a review in general. So what I see from February 28th, there was an order that the court entered relating to primary custody to Ms. Vaughn with parenting time for Mr. Kayoshi from Tuesday 11 a.m. to Wednesday at 6 p.m. with the exchange occurring up at the exit 72, and some decision-making authority was granted. So let me just ask Ms. Fellows, maybe you could start and then we'll hear from the parents related to any issues that have come up since or issues that you feel need to be reviewed here today.
Thank you, Your Honor. Yes, by the sounds of it, it has been going really well. I have been monitoring their discussions and their exchanges on Our Family Wizard, and they have been working really well with exchanging information. It's been really good. So I don't have any concerns about that. Both parties have been working towards trying to figure out and agree upon a parenting plan. So I have been somewhat involved in that, but really watching their exchanges on Our Family Wizard. It's been, again, very positive. It sounds like they had an actual discussion using the Our Family Wizard phone app. They had it last night, and by the sounds of it, it sounds like we are pretty close to an agreed parenting plan. The mom did some research and really looking and plotted out on like a spreadsheet of the time, and actually found that there is a span of time that's not being utilized that the dad could have currently in his visitation, which she walked me through her spreadsheet and everything else because it was a little bit confusing at first, but she walked me through it, and I give her kudos for, you know, really sitting down, trying to figure this out, trying to give the dad more time in and amongst all of the scheduling and everything else. She shared that information with the dad. My understanding was last night during this phone conversation, and it sounds like there's pretty much an agreement. So that's where I'm at. I would like to see that additional time be ordered going forward, because I think that is beneficial for the child and dad. There has been some movement about the preschool because that was a big issue between dad wanting basically a 50-50 plan. Didn't really think that it thought it was more important that the child spend time with him rather than going to preschool prior to kindergarten. Mom has gotten him preliminarily into Head Start LCC on a part-time basis starting in August or September. But with this new visitation plan adding the time, dad can still enjoy that time. However, he would need to bring the child back up here for I think it's the Wednesday school day, which is only like 3 hours, and then take him back home and then bring him back on Thursday, which really, in my mind, gives him a chance to engage with Corey, doing parenting duties, you know, getting him to school and stuff like that. But also it's possible that he could enjoy interacting with the school, maybe volunteering at Head Start and things like that. So all in all, this has gone very positively. I'm very, very proud and happy to say that both of these parents are moving forward towards co-parenting. They're still butting heads a little bit, but it's going much better.
Okay. Thank you, Ms. Fells. I appreciate that input. Ms. Vaughn, any perspective you want to share? Ms. Fellows indicated that, you know, things are improved from her view, and that you're working together on some parenting plan issues and maybe some timeframes. What additional input do you have?
So I did present them both with this idea of giving Zach parenting time instead of it being Tuesday from 11 to Wednesday at 6, being Tuesday at 11 to Thursday at 12. Right now, as far as I know, there's no disagreement on that. He was accepting of that offer. The only thing is that I know he wants it to be 50-50, 1 week on, 1 week off. And he said that he feels my idea is a good plan B for him, because his plan A would be 50-50, but that's where we're not agreeing on it. Him working full time would leave my child in childcare over 50 hours of the week, which would be the other days that he wouldn't have him, which are Tuesday to Thursday. And those are all days that I am available to care for my child. I don't work those days. So I think that with my plan that I proposed to them both, that it does maximize his time with his father. It allows him the most with what he has to offer Corey around work, and does give Corey the ability to begin preschool at the end of the year and still give his dad that time. And like Beth said, it does get him involved in Corey's school, which is a big part of a child's life. So I think it would be a good next step for us. It's not exactly what his dad wants, being that he wants 50-50, but I do think that since we are in agreement on it happening if 50-50 is not the way the court decides, I think that alleviates a lot of stress between his father and I as well, trying to figure out 50-50 or this plan, my plan, so to speak. So I think if the court makes a decision on that today, then we will be able to get a real parenting plan that we are 100% in agreement in going. Like, it can be filed as early as tomorrow because I already have it all templated out. It just is this one decision that's kind of halting that.
Okay. All right. Thank you. Mr. Kayoshi, what's your perspective?
Yes, we did talk about it. We got pretty far in coming up with some sort of parenting plan for both me and Alexandria. And we did talk last night about her proposal, and I did agree it was a good plan B for me. And without any arguments or anything, she kind of understood that I still wanted the week on, week off, and to hold off on preschool. So that's pretty much where we're at. We have a template set. We're waiting on this decision, and I still feel like I still want them 1 week on, 1 week off, and just hold off on preschool at least until, I told her when we talked last night that I wanted to hold off until the 2026, but even next year, I think would be okay. Would be okay with me having spent the 1 week on, 1 week off before he actually gets in school. So this is the decision we're at.
Okay. All right.
Or what's stopping us from moving forward, yeah.
Right, okay, so,
And Your Honor, if I may, really quickly,
sure, go ahead.
is that I absolutely appreciate the fathers wanting to have the 50-50 and really have that time. However, preschool is exceptionally important to children. And to this child, to Corey, he has never been in any daycare. He's not been in any preschool. So if he does not do this part-time preschool the year prior to kindergarten, he's, in today's day and age, he is seriously going to be behind. He's a smart little guy, but if he hasn't been in some kind of classroom setting with, teachers and other kiddos and stuff like that, he's going to be behind the 8 ball. So that's where I'm exceptionally strong in my recommendation that he does need to go to preschool this upcoming school year.
All right, thank you. All right, well, we'll first, just congratulations to the parties for working on things, parenting, co-parenting, and making good progress. I think that bodes very well for your child. So good job to both of you on that. So we're here today, and it sounds like the parties are getting closer to a potential agreement. The court doesn't have anything to do with any potential agreements. I mean, if the parties want to agree to something, great. The court's not going to involve itself in that. One thing to keep in mind is that we're here on a temporary order type basis, is that it's a temporary order because there hasn't been a trial on the matter. So it's temporary, and those can be adjusted as we go along. But when there's a trial, then there's a final order that's made that would finalize things. So these temporary orders are kind of stopgap measures with the idea that a trial will take place in the future. And if the parties aren't wanting the temporary order to continue, then at the trial, then there would be argument made for a different type of arrangement. So I'm all for parties resolving their differences amongst themselves. It's always better, I think, if there's equal bargaining power for parties to be able to do that without the involvement of a third party, meaning the judge. If you all can agree, that's better, I think, generally. So I think here that we have an existing order that sets out some parameters. The parties are looking at potentially expanding that. I know Mr. Kyoshi is looking at the 50-50 plan. And if on a temporary basis that's not agreed, then we'd need to set up for a trial and then make a decision on the 50-50 disagreement. So if the parties come to an agreement, then you'd need to file that with the court and just file it and send a copy to Ms. Fellows, so she would have to also sign off on it. If the parties don't agree, then I would want to see additional briefing from the parties, because from the date of the last hearing or the last order, that was February, end of February, a few months have gone by, so there's new information to be had. So there's a couple of ways we can do this. One, again, if the parties agree to something, then you could file that temporary parenting plan with the court and have Ms. Fellows sign off on it, and the court would sign it. If there's not agreement, then we need to set it for a motion and have a hearing with both parties submitting additional information about why your particular parenting plan schedule or residential schedule should bear sway and should control. So I don't want to artificially get in the way of the parties working on an agreement, and yet at the same time, I don't want things to flounder and not have something in writing that gives certainty to the parties.
Can I say something, Your Honor?
Yeah, go ahead.
So and thank you for so if Alexandra's okay with it, could you give us a month to see if we can agree on something and have it submitted to the court
Okay.
and come back then. If she's okay with that, I think we can figure it out on our own if we talk.
Okay. Ms. Vaughn, any thoughts on that?
I don't have any objection of coming back in a month, but I would like us to expand his visitation from now until then to the Wednesday overnight as well.
Okay, so doing the Tuesday at 11 a.m. to Thursday at noon.
Yes. And he is going to have to bring Corey all the way down. We won't be meeting at 72 on Thursdays because I work, so I'll be taking my lunch break to meet him.
Okay. All right, Mr. Kayoshi, are you comfortable with that? If the court were to enter an order today indicating that your visitation would be Tuesday at 11 a.m. until Thursday at noon, with the initial exchange happening at exit 72 and then the other exchange happening here in Cowlitz County?
Yes, Your Honor, I'm okay with that.
Okay. And then it sounds like Ms. Vaughn is comfortable if we were to set this for review for June 5th, a review to see if there's an agreement. If not, then we would just briefly touch base and say, okay, let's set out a briefing schedule when you're going to submit your motions, when you're going to submit your declarations, and then we can set a subsequent date for everybody to argue the case in the court to make a decision on that. Ms. Vaughn, are you comfortable with that?
Yes.
Mr. Kayoshi?
Yes, Your Honor. And then, so for this extended time that I do have him, that'll start next week, or?
Yeah, I think that's at least that was my impression, that it would start the week of the 16th of May. That would be Tuesday is the 14th.
So he has him right now, and like normally he'd be bringing him back at 6 p.m. tonight, but I'm okay with that beginning right now. Like he can keep him till tomorrow.
Okay. All right. So let me just take a quick note here, just a moment. So what I'll do, I'll draft just a brief bench order related to the visitation Tuesday, 11 a.m. to Thursday at noon with the exchange locations that we talked about, and that's starting this week. And then we'll set a review for the 5th of June, which will be at 9 o'clock in the morning, and we'll see if the parties have hashed out some type of agreement. If not, we'll briefly set a briefing schedule, and we'll set a motion date to hear it in the future. Any questions on that?
Is there any documents that you need filed for the next hearing?
No, it's on June 5th. If the parties have come to an agreement, I would anticipate that it would either be filed or that the parties would have it prepared and ready to go and for submission at that time. Okay, Mr. Kayoshi, any questions from you?
No, Your Honor, thank you.
Ms. Fellows?
Your Honor, if you could incorporate into that bench order that Mr. Kiyoshi is not to be under the influence of any intoxicants, as well as the child should not be around anybody who's under the influence.
That's kind of an extension from the earlier order.
Yes, yes.
Any objection to that, Mr. Kayoshi?
No, Your Honor.
Okay, I'll include that.
Thank you, Your Honor.
Okay. Again, let me emphasize the positive here. I appreciate the good parenting and co-parenting that the parties are exhibiting and working things out, and I appreciate your good efforts. We'll see you on June 5th. Thanks.
Thank you.
Oh,
Thank you.
Ms. McLean, I apologize. I thought I was trying to get all those cases done at once. I apologize.
That's okay.
So you're
I've been working
representing.
in the background.
Okay, you're representing Mr. Daly, and
I am, Your Honor.
okay, very good. And is Shariah Nielsen on the line today?
Yes, Your Honor, I am present.
Okay, welcome to you. Do you mind turning on your camera? Appreciate that. Thank you.
No problem.
And then Ms. Looney, are you on the line today? Just wanted to touch base. The state is involved, but not necessary for this. So this is a motion brought by Mr. Daly related to contempt. And and it's related to visitation. And when I looked at the file, I didn't see that there had been service upon Ms. Nielsen.
And I reached out to my client this morning. As far as my review as well, I didn't observe that. He indicated that his dad both mailed a copy of the orders and also personally served Ms. Nielsen. I can secure documentation from him and get that filed with the court. Obviously, she's here, so she would have been provided some notice, but I didn't also receive any or see any responsive documentation from her in response to the contempt motion.
Right. Okay. Yeah, let me just briefly touch with Ms. Nielsen. Ms. Nielsen, did you receive information related to the motion for contempt? In other words, did you get a copy of the motion for contempt and supporting documents?
Yes, Your Honor, I did. I got them in the mail.
Okay. And did you file something with the court as far as your input on that issue, or are we relying just upon your voice today?
I have not yet, because I wasn't sure how or like what papers I needed to get to respond back to the motion.
Okay, so there's a couple ways to proceed. Regarding the service issue, I don't have anything on file that shows that you were served with the motion for contempt and supporting documents. And so there's kind of a strict enforcement of that since you haven't been served with that, then we wouldn't move forward. We'd need to get that documentation showing that you had been served, and we'd come back and readdress the issue. That's one way. The other way is that you waive that requirement. In other words, you say, yeah, I wasn't technically served because the affidavit isn't on file that says I was served, and then we move forward today. However, we don't have your written response, and Mr. Daly doesn't see your response either. So my preference is to likely just set it over and have that proof of service filed, and then you'd have opportunity to file something in response, and Mr. Daly would have an opportunity to reply to your response.
Okay.
So Ms. Nielsen, are you comfortable if we were to continue this matter?
I would like to be able to respond back to the motion and have it set over if they're okay with it as well.
Okay, Ms. McLean.
Whatever the court determines, obviously our concern is enforcing the current temporary order on visitation. I guess I would just ask that the court provide a bright line notice to her that that order is still in effect. There's nothing in the temporary order that was entered on November 14th of 2023 that allows her to unilaterally cancel or terminate visitation. And so we would expect that my client's visits would resume tonight at 5 o'clock.
So I'm inclined to set the matter over to May 22nd, which is 2 weeks from today. So that means, Ms. Nielsen, you'd need to get your response in soon, hopefully this week, and then provide a copy to Ms. McLean, and we'd be back on the motion docket on the 22nd of May at 9 a.m. to hear argument. Then I also make note, and I think that's proper to take note of that, on November 14, 2023, the court ordered a visitation schedule that the father would have visitation from Wednesdays 5 to 7 p.m. and Saturdays from noon to 4 p.m. And I didn't see a particular provision in that parenting plan that allows unilateral withholding of the child. The allegation here is Mr. Daly has not seen the child since the end of February. So can you tell me if the visit that the court ordered tonight is going to happen?
Yes, it will happen. The last court hearing that we had, which was, I believe, on the 24th of April, we had decided to continue visitations from that point on.
Okay. All right. So we'll anticipate that that court order will be followed, and then we'll see everybody on the 22nd. Any final questions?
Yes, I'm sorry, I didn't get in my notes. So when is her response due to me?
Well, I didn't give a specific date. So if we look at the calendar here, today being the 8th, Ms. Nielsen, would you be able to have your submission by this Friday?
I believe so. If not by Friday, then by Tuesday the 14th at the latest.
Okay. Ms. McLean, with that? Okay, let's do that. Let's shoot for that goal at the latest, May 14th, submitted to the court and also copy to Ms. McLean, and then that'll give her an opportunity to respond, and we'll be back here on the 22nd at 9 a.m.
And is I'm not sure if my office has forwarded to Ms. Nielsen yet an email agreement, but we can do that. My preference would be that we serve each other through email if she's agreeable to that.
Any thoughts on that, Ms. Nielsen? Sometimes parties will agree to service by email as opposed to using the U.S. Post Office or personal service. Do you have any thoughts?
Yeah, and email them to her.
Okay, so Ms. McLean, it sounds like she has an agreement you can look over that basically says, hey, the parties are going to use email to exchange documents and serve each other documents. And if you're comfortable with that, you can review it and sign it. If not, there's no obligation to do so.
Thank you.
Okay. Any final questions, Ms. Nielsen?
I don't believe so at this point in time. I would like to state that if any court hearings land on a Tuesday or a Thursday, I have school those days from 9 a.m. to 12 o'clock.
Yeah, we can take that into consideration in the future if there's any date set for those. You can remind us of that. He's coming forward. and
Okay,
taking a seat at
thank you, Your
council
Honor.
table. And is Danielle Thomas on the line?
I'm here, Your Honor.
Okay, great.
I am currently washing my daughter's hair. So I'm just gonna finish that, but I am here.
You said you're doing what with your daughter's hair?
My daughter's in the shower. She's 9, and I'm just rinsing her hair out. I didn't know I was gonna be called yet. I apologize. But
Okay.
I am here.
We'll call you a case once you're finished with helping your child. How long do you think that'll be?
Like 2 minutes. The next case, if you can, Your Honor.
Okay. Mr. Thomas, you okay? Just waiting one more case and then we'll call your case.
My apologies.
Sure.
Okay.
I mean,
Well, let's do that. Get the girl out of the shower and get her prepped and ready to go, and we'll call your case in just a second. Is Ruben Kamba on the line?
Your Honor.
All right. Good morning, Mr. Kamba. And I'll ask if Desiree Kamba is on the line or present. All right. Looking on the Zoom call list, I don't see anybody by the name of Desiree Kamba or anything similar. She's not responding verbally, and she's not in the courtroom. This is your motion for contempt, Mr. Kamba. I wanted to ask you, in service of the documents, it looks like there was an order allowing alternate service using a 1312 South 4th Avenue in Kelso address. And that was an order that was entered in February. And it looks like you mailed the information related to today's hearing on April 12th. And then the question I had is, did you get any tracking information from the post office regarding whether Ms. Kamba had been served down in Arizona?
Attached the document, I believe, for the court that I did have, the receipt.
Yeah, I looked at that. Let me just pull it up again. That's kind of the basis of my question. So I'm looking at the okay, so April 16th, it looked like it was mailed to Ms. Campbell at the 4th Avenue address in Kelso. There was another document a little bit earlier that was sent on the 16th of April. So, okay, it's coming back to me a little more clearly. When we were last here, Mr. Campbell, we talked about the tracking information and that you had checked the website using the tracking number to see if delivery had actually taken place. And I was curious, do you have any more information about that?
I do not. I just have that document that I submitted.
Yeah. Okay. That shows the mailing that occurred to the South 4th Avenue address, correct? Okay. I wasn't sure if you were looking for something or if you were waiting for me.
Oh, I was just waiting for you, Your Honor.
Okay. All right. So I think service is proper here because it looks like there was an order allowing alternate service by mail, which uses the South 4th Avenue address. And I think that's corroborated and supported also with her last pleading in the case file, which she filed, and she used the South 4th Avenue address in Kelso. So the fact that you sent it there and there's service that shows that you did, there's been no response to your pleadings, and you're asking for a finding of contempt, a civil fine, and also jail time, and then a return of the child to you. That's what you're asking for, correct?
Correct, Your Honor.
Okay, you submitted a proposed order. Let me just take a quick look at that. I'm just adding on the second page, it's indicating that the court considered your motion for contempt, and we had a hearing on March 13th. I added to today's date and also April 24th. I'm just adding those two dates into that order. Then I'm just taking a look at the other dates. Mr. Campbell, I'm granting your motion for contempt. I am awarding the $500 civil penalty. Just making one change here, one moment. The last thing I'm considering, Mr. Campbell, is your paragraph 10, where it's requesting jail time in the amount of 365 days in the Calais County Jail. And that would be suspended under her bringing the child back to Washington.
And so if she doesn't willfully bring him back to Washington, she would get that.
That's what your proposal says. And I'm also going to, so let me just think about that for a moment. I'm also going to change paragraph 11 that talks about the purging condition. That I'm going to allow her to be able to purge the contempt finding if she complies with the parenting plan order and brings the child back to Washington.
And if she decides to just stay where she's at and hide, does this give me the ability to give this document to the police so that they can help me find my son?
As we've discussed in the past, Mr. Kamba, issues when a parent takes a child out of state and they don't return them are fairly complicated. There's means and methods that can be executed to bring a child back and get law enforcement involved. And that's why I suggested a number of occasions for you to contact counsel, to get an attorney. I think I gave you options of contacting the CLEAR hotline. Again, I'd encourage you to contact the CLEAR hotline, and they can potentially give you some assistance on this, what I consider a relatively complicated matter. And then also they may be able to give you a referral to a local attorney that might be able to take the case also. So the issues of whether this order will suffice for law enforcement, I don't know. I've seen it done in the past with other attorneys, and it's pretty involved. So if somebody doing this on their own, since I can't give you legal advice, I can give you options. I'm giving you the strong option of contacting counsel and getting an attorney on board to help you.
Okay.
So let me just finalize the issue of the jail time. I'm going to change the jail time to 10 days, and that can be suspended under bringing the child back to Washington. So the hope is that, kind of a wake-up call will help, but I've signed off on that order. You can get a copy of it, and we'll set a review hearing on the 22nd of May just to see if there's been any progress made with the attorney, and then if you need any additional, if you're making any additional requests, we can take those up at that time. So I'd really encourage you to get in touch with an attorney. The CLEAR hotline, CLEAR, just look it up with a search, online search, and they should be able to give you some assistance. Any questions, Mr. Kamba?
No, thank you, Your Honor.
All right, we'll see you on the 22nd of May at 9 a.m.
Yes, Your Honor, I can hear you.
Okay, you ready to go now?
Yes, Your Honor, my apologies.
Okay, thanks. All right, so we're here on Ms. Thomas's motion to modify the back child support. We were here previously, and there was additional information that was provided. So I'll hear from you, Ms. Thomas, first about your motion, then we'll hear from Mr. Thomas in rebuttal. Go ahead, Ms. Thomas.
So basically, my motion is the reason I am requesting to terminate the back child support is because Gunnar was not in his father's care a majority of that time. And I've paid over 3 years consecutive of child support. In addition, Daniel gets my taxes. So what I've learned over the course of this last year is the money that I'm sending for child support, Daniel's just misusing the funds. He has an addiction. He has
objection, hearsay.
The objection's noted, overruled. Go ahead.
He has been arrested twice within the last 6 months due to alcohol and violence.
Objection.
Basis.
She's just talking. She doesn't even know what's going on with the
Objections noted, overruled. Go ahead, Ms. Thomas.
And I can
go ahead, Ms. Thomas. Go ahead, Ms. Thomas. You'll have an opportunity, Mr. Thomas.
And so I feel that the money that I'm sending isn't going towards Gunnar's needs, isn't going towards Gunnar at all. The money's just being used for Daniel and Daniel's needs. Gunnar has been in my care majority of the time. I've provided 2 years taxes. In addition, I've provided, everything that I've provided to you with the court's declarations. And I just hope that the stuff that I've provided you, you've really considered I have 3 children that I support, 2 of which have autism and disabilities. I am still currently helping and supporting my son Gunnar, even though he is of age and 18. And this is just, it's just a very challenging situation, especially when I know that I feel as though I'm paying him child support for no reason. That's how I feel. And the money that I am sending him, he's just not using it the way it should be. And that's really all I have, Your Honor.
Ms. Thomas, did you mention that your position is that the child has not been with the father the majority of the time, and that you've been paying child support? Did you calculate an amount of the arrears that you believe should be modified or forgiven?
So I have paid over, when I first started paying child support, it was close to $30,000 in back child support. I am now down to, I believe it is $2,150. So I've paid a considerable amount, almost $10,000 in back arrears. And for the time that Gunnar was in his father's care, I do feel that the arrears have already been paid. And so I'm just hoping that the court is willing to forgive the $2,150 remaining.
So you're indicating, so there's a child support order that was entered in 2007 that requires you to pay $222 a month.
Yes.
And then you indicated that that Gunnar had not been living with the father from 2009 to 2024, but there were periods of time where he was with the father?
Yes. I mean, there were periods of time where he was with the father. Yes. I'm not denying that. Absolutely.
Like what amount of time are you talking about?
I know in 2000 and let me get my paperwork. In 2000 and maybe 9, I know that he was with his father. He just got reintroduced back to being with his father after the whole court situation. Daniel was not allowed to be in the care of any minors. So at that time, Daniel's ex-wife got custody of our son, Gunnar, temporary. It was like a temporary guardianship because there was some issues going on. And Gunnar was with Nefe Thomas for 6 years of that time. So that was in 2000. And I'm getting my paperwork right now. Then when Daniel did get Gunnar back about 6 years after he was taken, and he had him for, I would say, about a year. And then Gunnar decided to go stay with other people, which was his grandmother, because him and his father, he's scared of his father. He has a hard time being around his father. He's
Objection.
Basis.
This hearsay of what she's saying, she can't speak for him, and he's 19. He's 19.
Objections noted, overruled. Ms. Thomas, can I ask you a question? So you're saying that Gunnar was living with dad from 2009 to 2015 under the guardianship?
No, he was living with dad from 2000. And I got my court paperwork right here, Your Honor. I am so sorry. He was living with his dad from 2009 to 2010, and then went and stayed after 2010. It was like the next school year. He went and stayed with his grandmother. Then he went and stayed there for 3 months.
Basis.
Then he went and
Hold
stayed
on, Ms.
with.
Thomas. Hold on, Ms. Thomas. There's an objection by Mr. Thomas. Basis of the objection.
There's almost 2 years where he wasn't in my possession. I already had full
So
custody.
an objection is just a short statement of what the basis, like hearsay, like you've done in the past. If you're wanting to provide additional information in your version of the events, when it's your turn, you can provide that additional information. So go ahead, Ms. Thomas.
Okay. So then he went and stayed with Tony Harris, which was his father's ex-girlfriend. And he stayed there with her for about a good year, I would say a year. And then that's when he was returned back in my care and came and stayed with me. He's been with me since 2018.
So there's a gap there. So 2009 to 2010, Gunnar was with father. And then from 2010, he was with NAF, N-A-F-E.
No, yes. He was with Nefe.
Until when? 2010 until when?
2000. So, okay, let me see if so Gunnar was when he was with Nefay, he just turned 7, and that was he was with her for 6 years. Daniel.
Okay, 2010 to 2016.
Yes, because the state of what was St. Helens provided legal guardianship to her, and then after Daniel had proved himself to the courts, they allowed Gunnar to go back and do like weekend visits for an extended amount of time, and then after so long, it was about I would say a year, he was put back in Daniel's care. He was in Daniel's care for about a year before he ended up leaving Daniel's care and staying with other people.
So what was the time frame you spent a year with Dad?
Okay, so that was in 2000 and I would say 2009 or 2010, if I'm not mistaken.
Okay, so that's what you said earlier. And then at age 7 in 2010 to 2016, he was with NAFE. And
Yes.
then 2016 forward, he's either been with you or others.
Yes,
That's your
there
position.
is a gap that I am not accounted for because that's where my son was staying with his friends. He
Okay.
did run away and go stay with other people.
So the question I have, Ms. Thomas, if during that time when the child was not with the father and you were paying child support, why didn't you bring a motion to end the support obligation since you knew that he wasn't with the father?
Your Honor, I had an addiction problem. I got clean February of 2018. And at that time, I didn't know that I was able to do so. I had no knowledge of any of this until after I got clean and started researching and kind of figuring out what my next steps were.
In 2007, when the order was entered, the child support order, did you participate in that?
Yes.
Okay, so you're aware of the order and okay. All right. Okay. Anything else you want to share?
No, Your Honor.
Okay, we'll turn the time to Mr. Thomas. Mr. Thomas.
Thank you.
So since I got full custody of Gunnar, I've taken care of him. She did nothing to help except to make it more difficult and make false accusations, filing reports. So for over 18 years, I've been coming in and out of the courts. I do have 2 other kids with 2 other women. And Gunnar did stay with his mom. I did get in trouble until I had to prove my innocence again, or prove my side of everything, because that's all I spent is just defending my side instead of just raising my kid and having support. Like she's had support from the state for her kids that are autistic and all this. So I'm a single dad raising this kid, putting him through school, knowing he has problems. She couldn't be around to help because she has 3 other kids that have all these problems. The state were, hey, we can help you with this kid. You can't leave him at home, but yet you're supposed to be at work. So I did all that myself, and she popped in and caused this garbage. With my second wife, I did lose Gunnar for a little while. I got him back. He was with my wife, which I had another son with, and he was fine. And after that, I got him back and I had him. And I raised him up until, well, I guess 2018 is when she started getting clear. 2019, I got hurt on the job. Got my kids taken from me because I got hurt on the job. I could be a provider and take care of my kids and see them and be every part of their lives. But then if I get hurt being a provider and I can't even go to work, they take them from me, you know? And then they're garnishing me $750 a month right now just for child support on kids I don't even see anymore. I don't even talk to. I don't have rights to, but yeah, I can raise a kid. And then now she's like, I'd even take care of him this whole time. That's not true. I showed you the paperwork. She's only paid child support. Maybe the most of $1,500 is all she's paid in child support. And that's recently, that's all submitted in the court. I didn't have all that submitted last time. It's not about the money, it's about her being a part of his life. He started getting introduced to her. He started skipping school. He started going out and doing drugs. When he started getting his driver's license, he started buying past me because I wasn't going to let him get his license because he wasn't good enough behind the wheel because he didn't pay attention. I wasn't comfortable with it. As soon as he turned 16, he knew he wasn't good at his license, went around me, went to his mom, and he pulled that card. So there was all that stuff going back. And if a woman says anything in Oregon or in Columbia County, they'll just automatically grant it and assume it's set in gold and stone. That's how they are.
What's your position? You heard me ask questions about kind of timeframes of when the child was with.
So in 2009,
provide me some information related to that. I'll finish my sentence before you interrupt.
Sorry, 2000, I believe it was 2010. from 9 to 2010, there was about 2 years where I couldn't be around the kids until I went through the court process. Somebody made an allegation about me, cleaned it all out, and I had my kid back. And then at that point, I went through a divorce because of that process caused me to have a divorce because of.
So would that be
situation.
about 2009 to 2011 that they had the difficulties, and then kind of walk me through your timelines?
I can get the date from my mom because she was there. She remembers the date. She's right here. She's gone with me to all these courses. I don't understand the dates and paperwork because I struggle with that stuff. But
Okay.
I'll
So,
tell you.
so there was a period of time where there were some restrictions, or you weren't able to see her. So I didn't give you permission to speak. I apologize. So there was a period of time where you couldn't see them because some legal issues, and then the child came back to Gunnar came back to you.
Yes.
Okay.
So, and that
And
time
then-
I was not seeing them. I had to have supervised visits. So I was going there every week
Okay.
and every other week and seeing them, spending time with them, doing everything I could just because somebody made an allegation. It wasn't true. Went through all the stuff. I had to go through this process and the courts got involved. And this is like what you have to do. And so we did, and we got through it.
Okay. And then after you got through it, then how old was Gunnar at that time when he came back into your care?
He was,
Or what grade?
what was that? Not even middle school. I mean, he's just in, it was before high school
Okay. And then how long did you have him in your care?
the whole time. And then I didn't, then I had him in my care the whole time until recently where he was old enough, and actually the state came in when she got involved where he wasn't even going to school and he was skipping school. And then she was showing up there at school his senior year, and he was supposed to stay in school and actually graduate and get a better than a 2.0 GPA graduating school because he was on a modified diploma and an IAP. I mean, he had struggles in school. The kid did a lot. Like I could take him to school and drop him off at school, and then he'd just leave.
Yeah. Let me ask you a question. Ms. Thomas said her recollection is that from like age 7 to about age 13, between 2010
No.
and 2016, Gunnar was with NAFE or with somebody else other than she or you. What's your position on that?
No, it was 2 years, and my mom can say the dates if you allow her. She knows the exact dates, and I had the paperwork.
And that was 2 years with NAFE?
NAFE, yeah.
NAFE, okay. And then, so your position, so that happened sometime after 2011. So I'll put 2 years with dad, and then what?
And then he was back with me, and I raised him and had him in school and just going to work and taking care of him. No
Okay.
support from her.
Okay. All right.
And then I had my other son, Isaiah, and I was seeing him every other week.
Okay. And then I saw you filed tax returns showing that you claimed tax exemptions for 2021 and 22, or 2020 and 2021. Okay. Okay. All right. Thank you. Ms. Thomas, any additional response?
No, Your Honor.
Okay. All right. Thanks. I appreciate the party's patience and kind of your input and kind of walking me through your respective positions. It was a little challenging for me to understand the pleadings. So I appreciate the added input today. So there was a child support order issued back in November 2007 requiring Ms. Thomas to supply child support in support of Gunnar to Mr. Thomas. And that was to start in October of 2007. So there's been an accrual of back child support that it remains. Mr. Thomas indicates that Ms. Thomas has probably paid tops $1,500 during a period of time. Ms. Thomas was struggling with addiction and was not doing very well. And it sounds like during that time, Mr. Thomas was the one that picked up slack, and either him or his mother or Nafe was in a position to help provide care to Gunnar. Ms. Thomas was present for the hearing in which child support was ordered, and when asked about whether, what was her reason for not seeking child support modification when the child was not in Mr. Thomas's care, she indicated that she just didn't do that and wasn't aware. So I think here I'm going to deny the motion. There's a real lack of detail of what the dates are and what the amounts are that she's paid or hasn't paid. And so really there's just a failure of meeting the quantum of proof. So I'm going to deny the motion.
So now how do I appeal it?
You can file a notice of appeal. You have several options. One, you can file a motion for reconsideration that has to be filed within 10 days. And then thereafter, once the court has submitted its written ruling, you have 30 days from that point to file a notice of appeal with the Court of Appeals.
Now, can I ask you since I still have to continue to pay child support until I can get this straightened out and get the dates straightened out, is there any way where you can have it to where my taxes aren't taken? I do have other children.
So related to that, if you have a separate request, you need to bring a separate motion asking for whatever relief you're wanting. Serve Mr. Thomas a copy of it, and you'd have an opportunity to reply.
Okay, so now this, okay. And then how do I make sure you're not the ongoing judge?
At this point, the rules are that when a judge has made a discretionary ruling, which I've done here today, then prior to that, before a judge makes a discretionary ruling, any party has the right to file what they call a notice of disqualification, or sometimes they refer to as an NOD. Anybody can do that prior to the court making a discretionary decision. Once the judge has made a discretionary decision, you can't kick that judge off with a notice of disqualification, because the idea is that judges make decisions that people disagree with all the time, about 50% of the time. And so the idea is to avoid judge shopping. And so at this point of time, if you file a notice of disqualification, it would not be honored.
Because you, okay. So then I'll just appeal it, do what I need to.
Okay. All right. So I will submit the order denying the motion to modify the back child support, and that'll be filed. If either party needs a copy of it, you can get a copy of it. I'll ask if Monique O'Brien is present or on the Zoom call.
I'm here.
Okay, welcome to you, Ms. O'Brien. And I see that Ms. Corey, the guardian ad litem, is present. Thank you, Ms. Corey. And is Brandon James on the line today?
I'm here.
Okay. All right, welcome to you, sir. And let's see. I see Ms. O'Brien has her camera on, and just double checking with you, Mr. James. There you go. Great. I appreciate that. Thank you. All right. So we're here today for a review of the final guardian ad litem report. Ms. Corey did submit that. I read it. I'll just confirm with Ms. O'Brien. Did you receive a copy of that document?
Yes, Your Honor.
Okay. Mr. James, did you get a copy?
Yes, Your Honor.
Okay. So the guardian ad litem makes several recommendations related to kind of a tiered visitation process. And, if the parties still remain geographically separate during a period of once that week on, week off that's recommended, that there would be a reversion to a January 2023 parenting plan. Talks about a right of first refusal. Talks about disparagement, no use of mind-altering substances, including marijuana. Talks about counseling and medication and the like, and no disparagement of Mr. That Mr. Walker not be left alone without one parent there. I think that's what I read. Ms. Corey?
Your Honor, I did want to mention that it was pointed out to me that in recommendation number 5, on page 24 of that report, it should actually read no language disparaging Ms. O'Brien should be allowed in the child's presence. Typo on my part. My apologies.
So replacing Walker with O'Brien?
Yes.
Okay, that's what I kind of thought, but I wasn't quite sure. So thanks for the clarification. All right, so that's the recommendation. So let me just hear from the parties. Ms. O'Brien, if you want to go first, and then we'll hear from Mr. James to hear what your thoughts are related to those recommendations from the guardian ad litem.
I think it's fine. It's been 6 months since I've had any physical contact with the child, so.
Okay, all right. Thank you. Mr. James, do you have any input?
Yeah, I do have one question about the tiered program. When Ms. Twyla and I were talking, I thought she said the tiers were going to be longer. I thought she told me that they're going to be like monthly steps, but in the report it said 2 weeks.
Right. So you were thinking, like the first tier is 2 times a week for 4 hours each, and you thought that would be for at least 4 weeks.
Correct.
Okay, and then the same for the 1 hour, 4 hours one day, and then a whole day, that would be another full month, and then the Saturday to Sunday would be another full month.
Correct.
Okay. So with knowing that her written report differs from that, do you have any concerns with that or any input you'd like to share?
I mean, is that set in stone where it's only 2 weeks?
Key word here is their recommendation. So it's a recommendation of the guardian ad litem, and then the court makes the final decision.
Okay.
So if you have input related to that, I'm certainly willing to hear you and hear both parties.
No, that was my only question, was the length of the tiered steps.
Okay. So if it were to be the 2-week tiered process, may not be ideal if I'm hearing you correctly, but you'd be willing to follow that?
I mean, yeah. I mean, if you say it's 2 weeks, there's not much I could do about it at the end of the day.
Okay. But do you have any strong reasons or rationale why you feel it should be a longer period of time?
Like I said, when Twyla and I were just talking on the phone, I thought she said that it was gonna be quite some time until we get to overnights, not just a month and a half. So it was just a little confusion.
Gotcha.
I can clarify that a little if you like, Your Honor.
Yeah, if you want to provide some input, that'd be fine.
So when I initially spoke with Mr. James about that, I was actually thinking of maybe just a couple of steps rather than what eventually evolved in my mind to be this plan, and to do that in a tiered plan with 4 weeks at each level. I think it would have spread it out a little too far unnecessarily, and that's when I made the decision to go with 2 weeks.
Okay. All right. Thanks. Okay. So I did review that the recommendations from the guardian ad litem in light of the different issues that have been raised, and also the prior court hearings that we've had. So I'm fine adopting that. I recognize that there's maybe some concerns about the length of the tiers, but I think overall the tiered visits, when combined with the requirement for involvement in counseling and proper taking of medications and prescriptions, I think that's really important. And I also think that the right of first refusal is important also, that allows all parents to be able to care for the child if one's available and another one's working or what have you. So overall, I'm fine with the recommendation, and I'll adopt each of those recommendations in whole. So as a general rule, let me touch base with Ms. O'Brien and Mr. James. When a court makes a parenting plan order, these tend to be fairly involved, and there's lots of different pages. Generally, the court will have time to do, just so you know, the court doesn't have clerks, doesn't have attorneys on staff to help draft things and the like. And so pretty time consuming to do a parenting plan order that's probably 10 to 13, 14 pages in length. So generally we'll rely upon the parties to prepare that. There's a Washington courts webpage that has the forms kind of laid out, and then you just fill in the blanks where the information's there. So I'm looking to see if one of you would be in a position to prepare that order, the parenting plan order, based on the guardian ad litem recommendations, and circulate that to all parties, and then submit it to the court.
I can
Okay.
do it.
Okay, we got a jinx right there, and you both said it at the same time. Generally, let's see. The petition was filed by Ms. O'Brien related to a parenting plan, and it looks like Mr. James also submitted a proposed parenting plan. So it looks like both parties are obviously capable of doing that. Let me just take a look here. One second. I'll ask Ms. O'Brien to prepare the order, and then circulate it to all parties, Ms. Corey and Mr. James. And then let's return on the let's come back on the 29th of May. If all parties agree to what Ms. O'Brien has drafted, and of course it will be in accord with what the guardian ad litem has recommended. If all parties agree, then you can simply all sign off on it, submit it to the court, and I can sign off on it, and it'll be entered into the court file. If the parties disagree and there's disagreement, then we'd be here on the 29th of May, where you can express the disagreement, where the argument would be that Ms. O'Brien didn't get it right. And then we could resolve that and enter it at that time. So comfortable with doing that, Ms. O'Brien, preparing that order and circulating it for signatures?
Yes.
Okay, Ms. Corey, were you going to say something?
Yes, I'm actually out of town that week.
Yeah, you mentioned that before. Let's set it for June 5th as kind of the backstop. Mr. James, any questions about that process?
No, Your Honor.
All right, so Ms. O'Brien will get that order out, circulated to everybody. If everybody agrees, you can sign off on it, submit it, and we'll get it signed and filed. If there's disagreement, then we'll be here on June 5th to resolve that disagreement. But if it's already been submitted, then you don't need to be here on that day.
Okay.
All right, very good. Any last questions?
So are we starting visitation then?
Yeah, the tiered visitation begins. Let's have the effective start date. Let's have that start on Monday the 13th.
Okay. And does that mean there's no longer a restraining order? So we can have communication?
Yeah, good question. The temporary restraining order, that's the one that was entered in, I think, in December, is that correct?
I think it was October. I think it was in October.
Yeah, let me just make sure I've got the most current one here.
Did I fail to ask for communication via a co-parenting app?
Okay. Mr. James and Ms. O'Brien, do when she says co-parenting app, do you know what she's talking about?
I know there's My Family Wizard, but it's expensive, so I would need to be able to get a waiver for that.
Yeah, the
They
court
do
doesn't.
offer waivers.
So you'd have to make that application to the company itself. The court doesn't get involved in that process.
Okay.
Mr. James, do you have any questions on the co-parenting app?
I have no clue what that is, but I can get a hold of Twyla for more information on it.
Okay. All right. So as a general rule, a co-parenting app is basically it's a communication tool that allows parties to communicate with each other related to the well-being of the child and schedule and the like. And it records everything. And so it also allows phone calls, allows text messaging through the app. And so everything's recorded. And so there's kind of a monitoring element that Ms. Corey would be able to see and provide some, modicum of protection. And so everybody knows what the communications have been. So there's generally a monthly fee that it's like a phone app, and there's a monthly fee that has to be paid. So if the parties if you can't agree on that, or you've got concerns on that, I'll hold off on this at that point. And then we can come back on June 5th if you haven't come to an agreement, and then I'll make a decision on June 5th.
Okay.
Okay. All right. So then, Ms. O'Brien, your question, I don't want to forget that, related to the restraint order, whether that continues or whether that ends. Okay, so you're saying it was in October or before that?
I believe I was served with it in October.
I showed December 13th, 2023 restraining order that ended on January 3rd, 2024. And I don't see any additional orders beyond that. So it looks like by its terms, it expired on January 3rd, 2024.
Oh, okay.
Okay. All right. So we'll look forward to that that order if you can all agree to it. And if not, we'll be on June 5th at 9 a.m. I'll ask if Kevin Miller's on the line. We'll see you then. Thanks.
I'm right here, Your Honor.
Okay. Welcome to you, Mr. Miller. And Taylor Young, are you on the line?
Hi.
Okay. Welcome to you, Ms. Young. All right. So let me just pull up my notes. And Ms. Corey, are you associated with this case also?
I was associated with the case. I was released from it when Mr. Miller did not want to cooperate. But Ms. Young has stayed in touch with me and has kept me in the loop. I've also received other information on this case, and so I chose to be here for this today.
Okay. All right.
And I do have information to
All right.
offer to the court.
Very good. Thank you. All right. We're here today on Mr. Miller's motion for contempt and a motion for a restraining order. Before we get started on that, I just want to make sure that I'm clear on the service issue. So the restraining order that was issued on April 13th, I wanted to just touch base with Mr. Miller to make sure that that document was served upon Ms. Young. I saw that there was a picture taken of a document stuck in kind of between the door and the door jamb, and that was done by Jim and Danita Bartley. So can you help me understand a little bit more about the service of the restraining order on Ms. Young?
So I've had Centralia police officers try to go to that address. They couldn't make contact with her, and that's Taylor's last known address. She has taken my daughter out of Centralia School District, out of Jefferson Lincoln, enrolled her into Spanaway Elementary. Malaya, my daughter, has an address up in Spanaway that I've had Pierce County deputies try to make contact with her. She's kept my daughter out of school now for a week and a half after she found out that I had found her.
So let me touch base, just kind of going back again to the service issue. That's kind of my focus right now. That's kind of the first hurdle we need to talk about, and then we can go into the meat of the.
Yeah, nobody wanted to come to the door, so they seen that the person was trying to serve them. So I stuck it in the door, took a picture of it, and I submitted the proof of service that way.
Okay.
Because Taylor's been running from the police and everything. Everybody's been trying to find her.
Okay. So it says, okay, so I'm looking at the proof of service. It says, my name is Sarah Amber Damasio. I served the court documents to Taylor Young by giving the documents to Jim and Danita Bartley, a person of suitable age and discretion who lives at the same address as Ms. Young. And that's the one up in Centralia?
Correct.
Okay. And so how do you know that Ms. Young was living there with the Bartleys?
It's her last known address, and it's her grandparents.
Oh, so that's the grandparents' address?
Yeah, and that's what's on her ID as well.
Okay. All right. And it looks like what was served was a copy of the restraint order and a hearing notice. Is that correct?
Correct.
Okay. All right. Okay. All right. And so let me touch base with Ms. Young. Ms. Young, did you get a copy of the immediate restraining order?
I did not get a copy. I haven't seen the copy, but when I found out about it, I did contact the court. I did take her out of school because he started harassing, and under the circumstances, I did not feel comfortable giving her to him. He was just in jail for 4 months.
I
So,
was
so I want to just focus on, let's see, we're getting feedback from somebody here. I just want to focus on the service issue first. So it sounds like you were made aware of today's hearing. How were you made aware of the hearing today?
I called because the school contacted me that Cameron was, and then I found out there was a school resource officer who I tried contacting back because they left a card. I wasn't there. And I tried calling back and she wasn't in or available or in at the moment. And then that's when I contacted the courts because I tried filing myself. And like I said, I kept in contact with my attorney. They told me that there was court on the 8th. And so I spoke to her and she said, if I'm not served, at least to show up to the court date on the 8th.
So it looks like you also filed a declaration on the issue of contempt. Is that correct?
Yes, but that has not gone to him because I don't know his address. But I could give him copies via email or something, but I do not know his address.
Okay. It also looks like you filed some other reports related to some other copies of documents from a different court. It looks like the Lewis County matter.
Yes, and that's
Thurston, sorry.
And that's when I was saying not contempt because he was in jail for months. I tried getting in contact. I found out his sister had her. He was in jail. She put him in Jefferson Lincoln. When I found that out, I went to go get her.
So,
and
I apologize for interrupting. Just I'm still focused on the service issue. And so we're still not to the meat of the issue. So I guess the concerns that I have at this point is that service is required in all cases. Here we have Mr. Miller, who's indicated that an individual gave documents to, sounds like your parents up in Centralia, and then you filed a response to the motion for contempt. And then that response, I don't think, Mr. Miller, have you seen that response from Ms. Young?
No, I haven't gotten it. And her not knowing my address, that's false information because it's in all of the it's in all of the courthouses.
Okay. So let me ask, Ms. Young, the address that you filed as on your pleadings.
I use that as my mailing address.
Okay, that's the address where you can be served with documents. Is that correct?
No, that's just where I get my mail.
So that's the address where you can be served with documents, correct? If somebody were to mail documents to that address, you'd get them.
Yes, I could get them. Yes.
Okay. And then Mr. Miller submitted, I believe, he has an address in Rochester on.
Correct.
And that's where you can receive documents, correct, Mr. Miller?
Correct.
Okay. So I think I'm not necessarily satisfied with the service issue. What I think needs to happen is that, number one, I think the documents that Mr. Miller submitted or gave or provided in to the Bartleys by virtue of his service process server, pardon me. I think that suffices. I think that's fine. So I think there's good service on Ms. Young related to that. Ms. Young, you filed a bunch of documents that Mr. Miller has not seen. He needs to see those to be able to respond. So what's happening here is that Mr. Miller is asking for a contempt finding related to the spring break. Correct, Mr. Miller? That's your motion?
Correct.
Okay. So what I'd like to do is make sure all parties have in their possession are able to review what the other party has submitted and stated. So that means Ms. Young, you'll need to submit your documents and file or send copies of them to Mr. Miller at his Rochester address, and you can use the US mail. And then once he has those, if he wants to reply to those by submitting something, then he's free to do so. So you would need to send those out no later than this Friday to that address. So he would have them probably 2-3 days of mail, and then he'd have an opportunity to respond. So what I'm proposing is continuing the matter to May 22nd, which is a Wednesday morning at 9 a.m. So everybody can see what everybody else is saying and then discuss the issue. Any questions on that proposal?
Yeah. So with that, so since you approved with me filing the motion and she did get the information with the restraining order, when do I pick up my child?
Your Honor, I would like to say she's still in school. And
she's not. I've called the school.
He was in jail for the last 4 months.
So for me, on the receiving end of Zoom call, when there's crosstalk, I can't hear either of you. So the simple rule we use is that one party speaks. So at this point, the motion for contempt relates to the spring break. It sounds like there's other issues about the parenting plan and the like, that if it's not being followed, then an additional motion for contempt could be filed. It sounds like there's concerns related to the child being moved to a different address or to a different school, which may be the source of a motion for contempt. So in response to Mr. Miller's comment / question about kind of next steps about when do I get to see my child, my understanding is that there's a parenting plan in place and that the parenting plan has not been modified. So therefore that needs to be followed. and that's the expectation of the court. So go ahead, Ms. Young.
And there in the parenting plan, it states that they are in Longview. If you read the parenting plan, you're not supposed to move the child's schools. You're not supposed to introduce your child to a significant other after 4 to 6 months. I have on the 29th of March, because he was in jail, I got from Lewis County courts, they wrote an order that I got her back. They put her in Centralia. I don't live in Centralia. I won her back from his sister because he was in jail, and I put her in school where I lived. I didn't know when Cameron was going to come out. I didn't know what was going to go on next. He still has court dates. I don't know what's going to happen for the future. But when I had her, I did what I was supposed to do. I put her in school. She's already started baseball. She's starting to get on a routine. And I want to keep it that way. If he wants weekends, if that would work, because he works from the morning until 6 o'clock at night.
Ms. Young, do you mind just chime in here? So the question is related to the parenting plan. There's a parenting plan in place as of September 1st, 2023.
Mm-hmm.
That parenting plan controls, and it's expected that everybody's following that order. So it indicates that Mr. Miller is the custodial parent, and that Ms. Young, you have time with the child on every weekend, except the first weekend of every month, starting from Friday at 3:30 until Sunday at 6 p.m. So that's the current order. And also the order says there's to be no relocation without agreement or permission of the court. So the parenting plan is in effect. The parties are expected to follow that parenting plan at this point. So my proposal is to come back to talk about the contempt issue about spring break when we come back on the 22nd of May. And both parties are going to share information, make sure that you have each other's pleadings. If there's other concerns related to the parenting plan, either party is free to file a motion for contempt related to that.
Your Honor, so what do we do about school? Can he make sure she continues to get to school? She does not want to go to Jefferson Lincoln. She was bullied. He would know this if he would communicate with me. She loves her new school.
So the parenting plan talks about decision-making. The decision-making indicates the following. For school and educational, it would be joint decision-making between the parties.
And he was in jail for the last 4 months. So how was I supposed to communicate with him or anything when he was in jail?
Let's say something now.
So, Ms. Young, the issue before me is the issue of contempt, and then the follow-up question is related to what do we do now? There's a parenting plan in place that controls. If the parties have questions of what you need to do, you refer to the parenting plan. I'm not going to look retrospectively about what was to happen during the 4 months of incarceration. I recognize that poses a bunch of difficulties, but the issue that we're focused on is the contempt. We'll talk about that on the 22nd after the documents have been exchanged, and the parenting plan that was issued in September of 2023 controls. And if parties have questions, check with that. Mr. Miller.
So with the restraining order that restrains Taylor from Malaya and to put Malaya back into my custody, since Taylor is aware of it, correct, I should be getting my daughter back today because now she is in violation of the restraining order.
Ms. Young, there's an order that was filed on April 11th. It's a temporary restraining order, an order to show cause, and you're here today on that notice. And it indicates that just a moment, it indicates until the hearing that the child is to be with Mr. Miller. So that's the order of the court that indicates at that time, that order says that the child is to be returned to Mr. Miller.
So can I ask Mr. Miller what you're going to do about her school? There's a month and a half left.
So I'll let them discuss things separately amongst themselves. The order is what the order is, and we'll be back here on May 22nd. Again, the expectation is that if there's a court order, such as an immediate restraining order that requires the child to go back to Mr. Miller, then the child needs to go back to Mr. Miller. And then the other idea is that the parenting plan is in effect. So those two documents control at this point. And if there's not compliance, then we'll certainly hear about that on May 22nd. The court will take appropriate action.
Your Honor, where today can I meet Miss Young or her mother to pick up the child?
Any suggestions, Ms. Young?
I would rather it be in a public place.
Okay.
Fine with me.
Suggestion.
So can I speak real quick? I do work in Tacoma and I do work in the Spanaway area all the time. So if she wants to meet at the school this afternoon, I don't mind Miss Young spending. No, I can meet her at the school here in about 30 minutes. I'm on my way up there right now.
I'm not in Tacoma at the moment.
Where are you?
My thinking is tomorrow would be give a bit of a buffer and a bit of a transition period for the child. So let's plan for the exchange to occur tomorrow.
I need to prepare her for it.
I need to know where Miss Young's located so I can have an idea where to meet at a public
Can
place.
we meet at the Centralia Safeway?
Sure can.
Okay. Is there a time that would work better for you, Ms. Young?
Well, for me, it would be in the morning because then I can get Malaya back to her school on my way to work.
Okay.
So
Ms. Young?
Yes.
So Mr. Miller is proposing tomorrow, the 9th of May for an exchange time in the morning. I think he said 8 a.m. What do you think about that?
That's a little early. I'll just
How about I can do 10:30 or 11.
work.
Okay, let's set the time at 11 for the exchange to occur. And then both
Does
parties
that mean he
agree on
returns her to me on Friday?
whatever the parenting plan is.
Yeah, that's the parenting plan. I do get her
There's
back
a-
on Friday.
There's a restraining order that restrains
Until-
Malaya
but
from you
for what?
until
You
the
were
court.
Yeah,
jail.
that's a good point. I apologize. Mr. Miller raises a good point. There's a current restraining order in place that
Can you revoke it? Can it go away?
it can certainly be modified. It's certainly be modified. And I think what we're going to do when we come back on the 22nd, we'll need to talk a little bit more about it at that
So I
time.
can't see her till the 22nd. Can you keep her in her sports? Can you at least make sure she gets to baseball, please, for me?
There's a lot of difficulties that and issues that we're encountering at this point that, we're here on two issues. One is the contempt. We're going to talk about it on the 22nd, and on the restraining order. The restraining order's in place, and that Mr. Miller's right with that restraint. It's going to be in place until the 22nd, until we come back and figure out a little more clearly what's happening. So the parties have opportunity to speak, and that certainly causes difficulties for everybody, especially the child. So with the exchange set for tomorrow, the parties have agreed on that, May 9th at, I think 11 o'clock was the time. And then we'll be back on the 22nd to figure out next steps.
The 22nd of May.
22nd of May. And the location of the exchange was where?
Centralia Safeway.
Centralia Safeway. Okay. All right. We'll be back here on the 22nd. Thank you.
Twyla still have something to say?
Thank you, Your Honor.
I think she probably looks like she opened her mouth, so she probably has something to say. Go ahead, Ms. Corey.
I did have something to say, but since you have made your decision, I will.
I'm open to revisit it.
Okay. So this child has actually been in 3 schools since over the course of the school year. She was enrolled initially at Mint Valley Elementary when I was involved in the case. And in November, Mr. Miller's girlfriend and son were killed in a tragic accident. She did not return to Mint Valley after that, November 10th, 2023. She then apparently bounced around a little bit and ended up in Raymond with Ms. Denny's mother, who told me that she had her in her care at the request of Mr. Miller. She didn't know where Mr. Miller was at that point. She enrolled her unofficially in a private Christian school in Raymond and put her in counseling without the parents' permission. And indicated to me at that time that she had planned to honor the parenting plan and give Ms. Young her parenting time, which I don't believe happened after that. Then on the 19th, and Malaya was disenrolled from Mint Valley in December. In January, then her records were requested from Mint Valley in order for her to be enrolled in school in Centralia, which is the one I believe we're talking about. Then I learned from Ms. Young that Malaya had been withheld from her since before Christmas, and that Mr. Miller was in the Thurston County Jail, and I confirmed that. And around the same time, I learned that Mr. Miller's sister had Malaya and had filed in Lewis County for guardianship, which was eventually denied. In April of this year, I got an anonymous email stating that they were frightened for Malaya and that Mr. Miller is emotionally unstable and using narcotics. The email states that the sender is unable to provide specifics because of they were frightened because of his emotional instability. She's now in the 3rd school in 6 months, and I just hate to see her bounced back and forth yet again for the school year. While I was involved in this, Mr. Miller was extremely uncooperative. He told the commissioner in the case that he would not pay me. I've been following the case since because he still has failed to pay me. I served him with a notice of contempt hearing while he was in the Cowlitz County Jail. And then he was transferred to the Lewis County Jail, so did not attend that hearing. So I'd like to go ahead and I can serve him now by postal service since I have the address.
I have something to say. So yeah, I have no problem with payment. And I also have no problem taking a UA.
Okay.
Plain as a whistle.
I would ask for a hair follicle 17 panel to include
You
Suboxone.
don't need it. I can give you guys information to my counselor at not New Directions, but Cascade Mental Health, or my DOC office, or probation. Which one would you like?
So as far as Mr. Miller, you're indicating that you would be willing to submit it to a hair follicle test? Did I hear that
If needed.
correctly? Sorry, could you repeat that?
If needed.
Okay. All right. I think that's, if you're comfortable doing that, I think that, you know, that resolves any doubts. So if you're willing to do that, you'd need to submit to that and then submit sign a release of information, an ROI, and then supply that information to Ms. Corey and Ms. Young.
But what I don't understand is why I would need to do that if all I have to do is release information from Cascade Chemicals to Dependence, somewhere that I'm already taking UAs on a daily basis, or DOC that I'm taking a UA every Monday. So there would be no point for any of that.
Yeah,
if I was to sign release of information.
As you're probably aware, you know, your analysis is kind of a shorter term and catches things in the moment or within a few days, and then the hair follicle goes back a number of weeks.
I have no problem with it.
Okay. If you don't have a problem with it, then I'll order that. If you could take that and then supply that to the parties, that would be fantastic. So yeah, Ms. Corey's concern related to the movement of the child in different school districts is valid and very concerning. I agree, and yet we rely upon the parents to do their best to keep that stability, and hopefully that'll be in the forefront of all the parties' minds related to this. So
I have been in contact with Spanaway School.
Okay, so I'm going to continue with what I indicated before. I appreciate the input from Ms. Corey. So
That'd be him considering moving her to a different school without my permission or talking with me, because his sister put her there, not him. But if he puts
I never once stated if I was taking Malaya out of the school or putting her into the new.
Mr. Miller, Ms. Young was speaking and you spoke over her.
You just said that you were going to put her back in Centralia 5 minutes ago. She has a month and a half left and she likes her school. If we can make it work to where she can still go to school and play sports.
Ms. Young, there's the issues you're raising are super important. I have a room full of people still here. There's issues that need to be sorted out, and they're not going to be sorted out right now. And it has a pretty dramatic impact on the young lady. We will return on May 22nd at 9 o'clock in the morning. The exchange will occur tomorrow. The restraining order is here. We'll say, all right, welcome. Go ahead and take a seat and make sure you're in front of the microphone. It's close to your mouth. Then I'll ask if Sean Fields is present. Sean Fields. All right, there's no response from Mr. Fields, not necessarily surprising, in that there was a default order entered on February 28th of 2024. And so initially you had asked on the default, you had asked for a default as to the parenting plan. Correct. And then it looks like there was no request made related to child support at that time. So I'm in a position where I can approve the parenting plan based on the default. But as far as child support, since that wasn't raised as part of the initial pleadings and as part of the default, I'm not in a position to allow that order to go forward.
Correct.
Okay. And then there was also, I don't believe you asked for a restraining order in your initial pleadings that relates to the default. So I think I'm also kind of bound by that also, that I can't grant that relief since it wasn't requested and it wasn't part of the default order.
That's understandable.
Okay. So you submitted an order, a proposed order, I believe. So let me see if I can find that here. Okay, so I have the proposed orders. Let me take a quick look at that. So there's this one document, it's the final order and findings of parenting plan residential schedule. That's the one that I think it included the child support. So I think I can omit that from that order and sign off on it. So let me get my white out and put that there. Okay, so on this final order, I've made some adjustments to it based on the child support and the restraining order that we talked about before. So just so you know what I've done, under paragraph 10, under child support, I marked does not apply, changing it from the box that was marked court order. So I'm saying it doesn't apply. Then in paragraph 9, parenting plan or residential schedule, the box was marked does not apply. I scratched that out and I put today the court signed a parenting plan dated May 8th. Okay. And then on the restraining order, paragraph 12, the box was checked approved. I whited that out and put no one requested a restraining order in this case prior to the default. So I added that prior to the defaults, which I think is important to note. And then lastly, on paragraph 15, I'm approving the parenting plan, the residential schedule, and also the motion for default. And so I removed the child support order as being one of the boxes that was checked. So I whited that out, and then no other changes, and I've signed off on that. Okay. Then the last part is the parenting plan, which is here. And this parenting plan, just to confirm, is identical to the initial parenting plan that you proposed.
Right.
That's what I reviewed. I didn't note any changes. So I'll sign off on that. And then the child support worksheet and the child support order and the restraining order, I'll just hand those back to you.
Okay.
So you can do with those as you will. And the other two documents that I have signed, we'll give those to the court clerk and those will be filed. So if you want to come forward, you can grab those. And do you have any questions?
I do not, well, actually I do. Does this, actually mean that I have custody of him?
So the parenting plan, as presented, it grants custody to you. And then if there's concerns that if that order is not being followed, then you need to bring some type of contempt motion.
Thank you.
I'll ask if
right,
Tanya McWilliams-Rankel's on the line.
Yes.
Okay, welcome to you, Ms. McWilliams. I'll ask if Jose Rangel or Rangel Nino is present. If you're here, please state your name and make sure you're unmuted. Okay, not hearing no response, not seeing anybody come forward in the courtroom. This is on for a finalization of dissolution. Want to just ask you a couple questions, Ms. McWilliams. I know you've been at this for a bit.
I've been trying.
Yeah. What I'm focusing on is that there was an order to allow service by mail that was entered back in December. And that order, it allows service to the following address. Virginia Baeza 12, Puerto del Cedro, La Huerta, Jalisco, Mexico, 48850. So that's the address that was in the order. So then the affidavit where you submitted the declaration says, hey, I gave the petition, the summons, the declaration, all that information. I sent it to Mr. Rangel. It says that it was sent to Virginia Baeza 12, Puerto del Cedro, 48850, La Huerta, Jalisco, Mexico, which is slightly different than the order. That 48850 comes kind of smack dab in the middle of that address, whereas the order says the 48850 is at the very end, kind of like a zip code. So my concern is that 48850 in the original order kind of looks like it's the zip code. And then in the affidavit of mailing, it kind of puts it in there kind of like an address, like a house number at 48850 La Huerta. That's my pause of concern.
So when I look at it, it makes no sense to me.
Okay.
You know, like, because of how ours is written out. And so when I look at it, it really makes no sense to me. So when I took it to when me and Gabby took it to the post office, they were able to read it, make sense, and put it where it needs to go. But when it's written down on the paper, I'm just writing it how it was originally given it to me. So I don't know, but I know that I was able to track it and it made it where it was supposed to go. So
can I ask you on the tracking?
Does that make sense of what I'm saying?
Yeah, it does. Yeah, I follow you. I follow you. On the tracking, I think when I looked at that, it was like the certified mail thing, right?
Yeah.
And then it says it's for US mail only. So did you get something back from the post office?
Yeah. Yes. Actually, Gabby has that whatever they sent back. I didn't know if I was going to need it, but it sent it came back to her address because she's the one who that sent the mail. But I also have these that you have a copy of.
Yeah, I think that's the one that I was referring to. In the small print, right under the certified mail in the top portion, I think it says applies only to US mail. Or you
So this was the only way they said they could send it to Mexico, because I thought it had to be no, they called it registered mail, maybe. One or the yeah, and it does say certified on this, but she had to do it a little bit different because it was going to Mexico.
Okay. And she hasn't, and whose return address was on the mailing?
Gabriella's.
Okay, and has she received anything back?
Yeah, she said she has it. My car broke down. I haven't been able to get over there between work, and I just haven't been able to go pick it up. But I do have it, or she does have it, unless she got rid of it. I hope not, but she has it.
When you say it, are you referring to the
Whatever they
certified
sent back
receipt?
to her? Yeah.
Okay,
Yeah.
not the mailing itself.
No, whatever they sent back to her, she said that they sent her something back. I'd maybe saying it was signed for or not signed for.
Okay. Okay.
But I sent 2 copies. So
Okay.
one regular mail and then one certified.
All right. And then did you submit, I think you submitted a proposed order.
I probably.
Okay, I just looked through my papers here.
I've been working with Calitz Wakayakum Legal Aid, and I've just been doing step by step what, she's been helping me. So I'm a little lost on all this myself, but.
Right. All right, let's see what we can find here.
The problem with the whole thing is he's been in Mexico for almost 20 years now. We got married and not even a year later he was gone, and he's remarried, kids, everything, like this has been so hard to get this far.
Yeah, it's definitely not an easy process for sure. So you noted the matter up for today for a final dissolution order, basically to finalize this divorce. I'm fine. I'm notwithstanding my concerns about the zip code or the house number. I'm fine with the mailing because you've represented that there's been no return of those documents and that there's a certified registered document from the post office said it was mailed or delivered. I'm fine with that. I guess the next step is that I don't have a proposed order for the dissolution from you, and I'll double check again because I don't want to send you away with me having just overlooked some documents, but
I think I had another packet or another paper that I was told that I should turn in. But then when I went to turn it in, they told me to wait because they had a note saying to make this court date.
Okay.
So that could be what you're talking about.
Yep, I think that's probably the case. And so I double checked my file, and the clerk also verified that we don't have the proposed order. So I'm granting your request for finalization of the divorce based on your petition. So what we need from you, please, is an order of final dissolution, I think is what it's called. And you can double check with the Calais Wakaikam Legal Aid, and they can point you to the specific order or form of the order. You can also look at the court's website. It's courts.wa.gov/forms.
Okay.
And then you can go there and you can pull up a Word document and fill it out. So I'm going to rely upon you to do that. And then I'm going to set the hearing on the 22nd of May to make sure that we've got that order. So you'll fill it out, submit it to the court for signature. If we get it before that date, then we obviously don't need to be here on the 22nd. We can strike it. If I don't have it on that date, then we'll be here to address any issues that you may have encountered.
Okay, so if I do turn it in, I don't need to be there.
Correct.
Good, because I probably end up working that day anyway. All right. Thank you so much.
All right. Thanks very much.
Thank you.
Excuse me, Your Honor.
Yes.
Would my case be able to go next? It's just to drop a restraining order.
You're the next one in line. So Barbara Sawyer and Cole Norgan. It sounds like Ms. Sawyer's present, correct?
Yes, Your Honor.
Right. And then Cole Norgan, you're present.
Yep.
All right. Let me just pull up my notes. Okay, so we were here previously. We talked a little bit last time, and there was an extension of the immediate restraining order from the 24th of April to today. And I remember, and you can help refresh my memory on this, both of you, related to there's some information about reports from CPS and the CJAC, and that we were holding off on visitations till today until we got more information. Does that sound familiar to you?
Yep.
Yes.
And do we have any additional information from either of those sources?
So Officer DeLapp did visit with Lila. He did not find anything, so we are good to drop it today.
Okay. Mr. Norgan, are you in agreement? Do you have additional input?
Yep, same information.
Okay. All right. So with that, I think that I also saw a notice of the mediation that you had both participated in mediation and had potentially agreed upon a parenting plan.
Yeah.
Yes.
Okay. All right. Okay. So at this point, the immediate restraining order that was issued originally, not sure the exact date. I should know that here. Just one moment. On April 8th. So that April 8th order is extinguished, ends today now. So that order is extinguished. Do we need to address any other issues today, Mr. Norgan, Ms. Sawyer?
No, Your Honor.
Okay. So I will make sure that order is submitted today. Sawyer v. And that'll be an order that terminates the immediate restraining order, from April 8th. Okay, I'll get that done. Anything else? Any questions, Ms. Sawyer, Mr. Norgan?
Nope.
No.
I appreciate your patience of 2 hours and 53 minutes of waiting for a very short hearing.
Thank you, Your Honor.
All right, thanks for being here. Please, you're perfectly positioned. That's great. And then Mr. Roach, you're present. Great. If you go ahead and just position yourself in front of that microphone and get it close to your mouth. This is on for a motion for temporary orders brought by Ms. Roach. So as far as the service, it looks like I saw service of the petition and summons, proposed parenting plan, financial declaration upon Mr. Roach. looks like on March 1st. Did you get copies of those documents, Mr. Roach?
No, it was not served.
Okay, so I'm looking here on, I'm just going to pull up an affidavit of service. So I'll share with you what I'm seeing. This is filed on March 4th. It indicates Barbara Thomas is not a party to the case, and she served documents to Joseph E. Roach Jr. by giving the documents to Bo Nelson, who is a person suitable age and discretion who lives at the same address of the party, which is up on Mount Brinion in Kelso on March 1st at about 7:13 p.m. And that was signed on March 1st. So that's the information I have.
My dad's never met her friend's mom that supposedly served him, and he's here to say that never happened.
Okay,
And
so
I'd
you're
like to continue this on until I speak to council.
okay.
I'd like to say that Barbara has the same name as her mom.
Barbara
Barbara Thomas
Thomas.
is 33. She is the daughter of Barbara Thomas.
My dad never got any paperwork handed to him.
Okay, and your dad is Bo Nelson.
Yes, and he's sitting right back there.
Okay. All right. So let me just go back a little bit. Let's kind of pause on that for a second. We'll come back to it. The second issue I just wanted to briefly address is a notice for today's hearing. Looks like that was Ms. Roach, you filled that document out, a notice of hearing for today's hearing.
Yeah.
And did you supply a copy of that to Mr. Roach?
I paid Cowlitz County Sheriff's to serve him.
Okay. All right. So that particular, and did they give you a document back that they had served him?
I have not gotten anything. When he was served a harassment order, I got it in the mail saying that they had served him, but I haven't gotten
Any of that
service.
back from them?
No.
Okay. All right. So normally, and I'm sure you're probably both fairly well aware of this, but as far as one of the bedrocks of our system is notice and opportunity to be heard. And so there's kind of an initial threshold issue that we need to resolve is the issue of service. So whether Mr. Roach was served or not served, apparently there's a dispute related to that. So I think we need to hear, we need to have a hearing related to a hearing from Barbara Thomas, who indicated that she served, and then
I have audio on my phone or Barbara's phone of Bo receiving the paperwork from me because it was during a visit exchange because there is a restraining order against Joseph and I. So Bo was receiving the kids and took the documents from me.
okay. Oh, wait. Who's talking? No. You're not a party, you're involved. And it's pretty clear from the way we proceeded today that I'm not allowing third parties to enter into the discussion. So if I need your input, I'll invite you to provide your input. You're not free to just interrupt the proceedings. Any questions on that? Yes, no? Thanks. So there's a dispute as to service. We're not going to have the hearing today. We're going to set it over for a period of time to allow parties to prepare for that. So you can bring your witnesses, you can bring your audio, you can play it, and then we can make a determination if there was service and if there wasn't. If there was service, we'll move forward with the motion. If there's not service, then we'll have to take a different tack.
Your Honor, my biggest concern right now is that my kids have not seen their dad due to fear of.
Don't interrupt. It's
So
pretty clear how I've run my courtroom here today, and I'll just reiterate the process. When one person speaks, I allow them to speak. People don't interrupt. Because I'm the judge, I have a prerogative. Sometimes I need to direct people and sometimes I do need to interrupt. And so I reserve that for myself. But as a general rule, I allow people to say their piece. And then once they're done, then I'll allow you to say your piece. And then once you're done, there'll be no interruption of either party. Go ahead.
So I understand that we're not putting anything in place today, but my kids have not seen their dad since April 7th when they were returned to me, due to having false allegations put on me. I had CPS called on me saying I was on drugs, which I will gladly take a hair follicle for. CPS obviously said I wasn't on drugs. They have dropped my case. So my concern right now is I want my kids to see their dad. They need a relationship with their dad just as much as they need a relationship with me. And so I would like something in order if that's possible. That way I know my kids are going to be returned to me on Sunday if I send them on Friday.
Okay.
And there weren't any issues with Friday to Sunday before the CPS matter was brought up.
Okay. So the issue that we're talking about today, the threshold issue is service. We still need to sort that out. So I'd invite the parties to come to court next week on the 15th at 9 o'clock in the morning with witnesses. It'll be a very short hearing. Witnesses will be put under oath and you'll share your information. So if Ms. Thomas is available, make sure that she's available. And then if Mr. Nelson is there, make sure he's available and we'll hear testimony.
Sorry, can I correct her last name? Her last name is Bartlett. It should be Bartlett on there.
If you need to file an amended document, you can do that. Verbally, I'm not going to do that. If you want to file an amended proof of personal service with a different name, well, the document I'm looking at was filed on March 4th. It says, my name is Barbara Thomas. I'm not a party to the case, and I served Joseph E. Roach Jr. by serving Bo Nelson.
Okay, I'll have to see if she changed it on her ID or not.
Okay, all right. So we'll be back here on that date. As far as the request for a kind of a temporary parenting plan or the like, I'm not going to entertain that at this point. The substance of the issue is the parenting plan, and then we'll address that next week if we get beyond the threshold of the service issue. Any questions?
No, that's it.
Any
I
questions?
don't plan on keeping my kids from her.
Okay.
I don't see the
So
reasoning behind it. I haven't done anything, never kept my kids from her.
So yeah, so the issue is the parenting plan. We'll take that up next week if we get beyond the service issue.
All right.
Thank you, Your Honor.
Okay, great. Let's everybody then. We have Ms. Keegan is present.
Yes, Your Honor.
All right, and Mr. Trotter is making his way up, it looks like. We'll wait till everybody gets settled and we'll go ahead and get started. Okay, you're Mr. Trotter?
Yes, sir.
Okay, very good. All right, we're here today on a motion related to a restraining order. It looks like the restraining order was entered back on April 19th of 2024 with restraint on Mr. Trotter. And I show service of the same, looks like a summons, a petition for dissolution, parenting plan, birth certificate, financial declaration, restraining order, and motion for restraining order was served on Mr. Trotter on April 22nd. Did you get those documents?
Yes.
Okay. All right. And so and then as far as today's motion, let me just double check. I reviewed the documents that Ms. Keegan had filed with the court, also the return of service, which we mentioned, and then a series of about 70 pages of documents related to emails. It looks like, well, text messages, I guess. It's kind of slow in downloading, so I don't remember exactly off the top of my head. And then, so I just want to confirm with you, Mr. Trotter, sometimes people will submit something in writing in response to what they've received. Other times they'll just come to court and just rely upon their voice. Did you submit anything with the court?
No, I didn't know that I was supposed to. I have notes and stuff, but I didn't bring anything. I have a lot of documentation to dispute a lot of the things that I read that she had said when I was given the papers or served or whatever, but I don't have anything here today. I thought there would be another hearing or something, and this was just an initial thing. I didn't know I would have to be so prepared.
Yeah, so just procedurally, there was a motion for an immediate temporary restraining order, which was entered back on the 19th of April. And so it's temporary in nature, and it's kind of an emergency immediate thing. And then the notion is, hey, we're going to come back to court and talk about this a little bit more. And then that's contained within the temporary order. And so that temporary order indicates, hey, on May 8th at 9 o'clock, we're going to come and we're going to talk about this order. And it potentially would end at the end of today's hearing. So kind of the general idea is that there's notice that this restraining order, that's going to be the topic of today's discussion.
As far as that goes, like, yeah, I don't have any like review to that, or as far as that restraining order situation goes, that's not the things I was talking about.
Okay, so just to make sure I heard you correctly, because the door kind of opened at the same time, could you just repeat the first part of what you said?
I understand the situation regarding the restraining order and the part that I played in it, or temporary restraining order, whatever it is, and that's why we're here today. And the things that I was referencing a minute ago that I said I had like refutable documentation to her claims, those are separate from the restraining order situation. So I don't have any like reserves or anything.
Okay, okay, and then child Brooks is under 6 months.
Yes.
So it's newborn.
Yes.
Roughly. Okay. All right. Ms. Keegan, as far as that immediate restraining order, are you asking that the restraint continue, or are you asking that it end today?
I don't see why I should drop it at this point. He's threatened me multiple times, so I don't know. I didn't know what he was going to say, what his response was going to be to that. I haven't spoken to him, so.
Okay. Mr. Trotter, what's your response as far as that restraint order? Are you asking that it be dropped today, or are you agreeing that it continue?
Do I have to speak into this? Can you hear me?
I can hear you. It's helpful. It's not so much for amplification, it's more for the recording.
Oh,
and so if you're close to it, it's helpful.
I don't see any reason for it to continue. I would have tried to resolve the situation and talk to her about things that happened before, but I didn't know if it was in violation of the temporary restraining order. So I figured I was supposed to not have any contact at all. So okay. I would talk to her. You've seen the things that were said, and I don't think the nature is as heinous as she is kind of trying to make it out to be, although I do realize that I was in the wrong, and it was more just like I don't know, like a psychological duress thing than it was like an intent to do anything stupid. So I feel like that if we actually had an opportunity to speak about it, that it could be a pretty easily resolvable issue, but I don't have any malice or ill intent towards her or my son for that matter, like never at all. But I don't really, to be honest, see a reason to continue with the restraining order, and I would hope that we would be able to get along somehow or resolve this or whatever the process is.
Okay. Right. Give me just one moment to just look over the temporary restraining order.
One more thing.
You can. Sure.
I realized, so at the time I didn't realize some of the things and kind of like the I guess the serious nature of the things that some of the things that I said. And I didn't realize that it would end up in a situation like this. Not that excuses them or makes them okay or anything, but I kind of realized, like, for lack of a better term, the game that we're playing at this point and the things that are acceptable to say in conversation and the things that are not. So like I said before, like never had intention or anything like that, but I was just upset and saying things. And I get now that that's over the line. It's not even, close to like a thing that we can flirt with or, make jokes about or in regards to anything like that.
Okay. All right, thanks. So I appreciate the input from both parties. So I reviewed the text messages, and I just wrote down a few of the quotes, and I'll just read some of these. You better get a bodyguard. I have nothing, no family, nobody cares about me, nothing to lose. And these are quotes from the text that are coming from Mr. Trotter. It says, the way it ends, he won't have either one of us, in reference to the child. Can't wait till you push me all the way and I have no choice but to do what I have to do. Keep it up, keep pushing, please. Never felt a seething hatred for someone like you. What comes over me when I think of you. So when one takes kind of an objective look at that language is exceptionally alarming. It's alarming. And I think it's sufficient grounds to continue the restraints. So I'll continue the restraints. And then what sounds like is that there's a petition for dissolution. There's a petition for a parenting plan. That's kind of the next steps. The next steps will be a temporary parenting plan. The parties, I believe, Ms. Keegan submitted a proposed parenting plan. And Mr. Trotter, I would anticipate you would be filing a proposed parenting plan of what you want to see the parenting plan to be. And each party can support your respective positions of parenting plan with your own declarations, your own words written down. And then under the local court rule, if you look at the webpage, the court's webpage, it's Rule 88. It gives you some guidelines on how many people you can have submit declarations and the length. So if you just want to go to the Cal Superior Court website, look under rules, find local Rule 88. It'll give you guidelines of how many declarations and the like that you can use to file. So I guess the next step is, because there's this temporary restraining order, I think, at least from my vantage point, what I'd like to do is hear from the parties more about the temporary parenting plan, what you feel is appropriate for your child. And so I need to have additional information from the parties. And I want to set a date for us to come back where you both will file what you want and with your supportive declarations from yourselves and others. And then you'll serve copies to each other via mail. If the parties want to agree to do it by email, that's fine. Otherwise, it'd be US mail. And then we would come back and hear argument on what the temporary parenting plan should be. And then I'd make a ruling related to that.
Your Honor, I have a question.
Go ahead.
So in the parenting plan, I did put that I would like full custody of him. Eventually I was hoping, I would like him to have a relationship with him at some point, but I don't think with the way and what I've witnessed so far, it's a good idea. I think that the way that he speaks to me, he's going to do it to him. And I think he needs to put in some work first before he can have a relationship with him.
Okay.
So that was my proposal. I don't know if I need to fill it out again or if I would just do the same thing or.
Well, you've submitted a proposed parenting plan of what you think the parenting plan should be in kind of proper format as by the forms. But I don't recall reading a specific declaration of kind of laying out your rationale. So you kind of need to do that. And then Mr. Trotter would need to do that also, explaining his rationale for what his view is. There's also the possibility, I'll just throw this out there, of the appointment of a guardian ad litem, a GAL. The GAL is a court-appointed investigator that talks to both parties, talks to family members, people that know you, and then does an investigation, and then makes recommendations to the court of what's in the best interest of the child. And that relates to all aspects of the parenting plan and all aspects of any concerns that the parties raise. So they investigate into that. So that's something that's probably coming on the horizon that we'll probably talk about at the next hearing. So just want to make sure that the parties are clear. So number one, the restraint order, I'm going to continue that temporary restraining order as is until our next hearing, when we'll address the temporary parenting plan. So between now and then, the restraint order will remain. And then between now and then, you'll need to submit your proposed parenting plan, which you've already done. You'll need to submit yours, and then file your declaration of why you feel your position is the correct and in the best interest of the child. And then using that court rule 88, you can look at how many other people you can have submit declarations in your behalf and the length that they're limited to. So you'll be, so let's take a look at the next date. Today, we're the 8th. I'm proposing the 29th, just to give the parties a little more time to get everything together and serve each other. So I'll just ask the parties of what your availability is on Wednesday, May 29th at 9 a.m. Ms. Keegan.
I'll be working, but I can probably get is it gonna be the morning time?
Yeah, it'll be the morning time or afternoon time. Usually we're done well before noon, but sometimes we go a little longer.
Okay, yeah, we'll just put us down for that day and I'll
Okay.
figure it out.
Mr. Trotter? Okay, you're available 29th. Okay, so let's set that on the 29th of May at 9 o'clock in the morning. That's where we're going to address two principal things. One is the temporary parenting plan, what that's going to look like. And then two, whether the restraint order needs to continue or if it's going to be kind of subsumed and taken control of by the parenting plan. Because the parenting plan can have restrictions in there if needs be. So those are the two issues we'll address next. So let me just touch base with both of you. Do you have any questions at this point of kind of what next steps are?
I just want to make sure that I have what you're telling as far as documentation goes,
Sure.
because I tried to do all of it by myself and it was extremely hard. So it's the parenting plan and then you said the declaration.
Yeah, you've submitted your proposed parenting plan. You've already done that.
Okay,
So you have what you want me to do, but then I need from your explanation, your rationale, your thinking, why you feel that's appropriate. And that's
okay, so
basically
it's
your
just something I
declaration.
write it myself. Okay,
Right.
got it.
And then both parties would do that. And then both parties, you can have other people that are familiar with the situation of the child, they can write declarations and submit those to the court. So when you submit something to the court, you always have to serve a copy to the other party. So just make sure you do that. And then you have to file a document that says affidavit of service or declaration of service that says, hey, on such and such a date, my friend sent a copy over to Mr. Trotter, over to Ms. Keegan. So just be aware of that. Also be aware there's a good website. It's called WashingtonLawHelp.org. It has a section on divorce and parenting and custody. Lots of explanations. They have forms there. So it's a really good resource. There's also the CLEAR hotline. You can look that up on the website. You have to meet certain income criteria. If you meet the income criteria, you can talk to an attorney and they can give you advice. So that's kind of where we're at.
Okay.
Any questions either? Yeah, Mr. Trotter.
Am I allowed to like ask her, like talk to her as far as like asking if I can see my son ever? Am I not supposed to? Or is it like as far as the restraining order goes, does that mean like no texting or saying anything at all? Or I don't know exactly like from what I've read on the stuff that I was served, it didn't say like don't text or call. It basically said like don't say anything stupid or do anything stupid, like more or less. So but I just wanted to clarify because I would love to see my son, obviously.
So the restraints that are there currently are a restraint on disturbing the peace of the protected party and the child. There's a restraint on staying away. In other words, don't go to the home of Miss Keegan, her workplace or school or the daycare of the child. There's also a restraint of not assaulting, harassing, stalking, or molesting, and not trying to use or using or threaten to use physical force against the protected party or the child that could be expected reasonably to cause bodily injury. Also, the paragraph 10 says that the child to live with the mother basically until the next hearing. And then it goes on, and that's the last little bit.
That's fine. So it doesn't say that I can't like ask if I can see him, right, or anything like that.
Let's see. There's no specific order within there that says that there cannot be communication between the parties. There is the restraint of not disturbing the peace, not threatening, harassing. Sometimes people can get over anxious and send too many text messages or call too many times, and that can be considered harassing. So there's caution to be exercised there. So as far as communication between the parties, I don't see that that's prohibited. Ms. Keegan, in that order, did you see that?
I did not. I thought it was no communication at all. And that's fine as long as I'm not being threatened or harassed. But I just don't see how me letting him see him would be abiding by that order, because he has to come to my house to see him. He can't take him to his house. He has no resources for him at all. And he's never taken him by himself. So
yeah, just so the parties are clear, at this point that the order says that the child shall live with the mother until the next hearing. There's no provision for visitation during that period of time. And there's also a restriction on just staying away, not going to the home of Miss Keegan, her workplace, or the daycare of the child. So that practical effect of that may mean that there's no visitation between now and the next hearing. So I think that's a reasonable interpretation of that. There's no limitation other than the harassment issue as far as communicating between the parties. But there's no obligation of Miss Keegan to agree to any visits at this point, because at this point the temporary order says that the child is to live with the mother. That makes no other provision related to visits. And I think at this point, just given the nature of the the concerning quotes that I mentioned earlier, I think it'd be inappropriate to have any contact at all. And sometimes the concern is that one parent will use the child as a means to get to the other parent. So we're going to try to avoid that at this time, and we'll clarify that more on May 29th. All right, any questions at this point?
One more question. As far as the parenting plan goes, at the next hearing, will the child support order also be addressed?
You'd have to, in your, let's see. In your initial petition, you asked the court for an order of child support. You've provided some financial information about your financial situation, and a W-2 and some pay stubs. So yeah, that's a proper issue to be addressed at the next hearing also, child support. So just be aware of that, Mr. Trotter, that will also be an additional topic of conversation is child support. And so just so you're aware, the court needs to make a determination. The court needs to determine what your incomes are, your gross and your net income. So any information you have that relates or helps the court or inform the court of what your wages are, what your annual income is or monthly income is, like pay stubs or W-2s would be helpful, and that would be something that would be appropriate to submit.
All right, I'm sorry, one more. There was also in the parenting plan, I don't know if it was in the child support order, but I put something stating there is a small claim for a credit card for a property that he sold of mine. I was under the impression that we would address that since it was in the plan, but I can file, if that's separate and I need to file a small claim, I can do that separately too. I just wasn't sure.
Generally, when there's a petition filed for dissolution, there's division of property and assets and debts. Here, the form that you filed is asking for a petition for parenting plan and child support. So it doesn't address necessarily division of property.
Okay, so that's separate then.
It is separate.
Okay.
As a general rule, when parties are divorcing, I think that the goal and the intent of the process is to resolve all outstanding issues. So if that's something you feel should be addressed, you could file a motion related to that. Do you have any questions?
No.
Okay, so we'll plan on being back here on May 29th. Please look at that Court Rule 88 because it gives you some time frames as when you need to file things. So I'm giving you a bit of a lead time, but you're going to have to kind of dig in quickly and look at that and make sure you get the filings submitted and then copies to the other parties. Okay.
And that was courtroom 88 or court?
Local Rule 88. If you just go to the website and you'll see a big blue button that says rules, click on that and it'll take you to look for, you can do Control F and do 88 and it'll take you right to it. All right. Any final questions before we see each other on the 29th?
No, Your Honor.
No, sir.
Okay. All right. We'll see you then. Thanks.
Thank you.
I'll just mention, Ms. Keegan, if you need an escort to your car, we can contact a police officer to escort you to your vehicle if you'd like. Okay. 08, Mr. Jensen's in the courtroom coming forward. Thanks for your patience, Mr. Jensen. Ms. Rhodes, are you on the line? Ms. Holder.
Good morning, Your Honor. Yes, I'm here representing Ms. Rhodes and she is on the line.
Okay. Ms. Holder, I apologize. As a general rule, I try to call attorneys earlier in the docket, and my apologies. I failed to do so today.
Knowing that, Your Honor, next time I'll be sure to put in the chat box.
Yeah, that's helpful. Thanks. Okay. So Mr. Jensen, we were here on the 24th of April. We had a hearing at that time. There was visitation that was afforded, unsupervised visits Thursday to Monday at school. I think simply we're here on a review hearing. Ms. Holder, you've filed a notice of appearance. Is that accurate?
Yes, Your Honor. I believe my office has filed one for me.
Okay. I assume it's in process. Maybe that's part of the reason why I didn't catch on earlier. It still hasn't hit the court file, so just double check to make sure that occurs. So let me just ask Mr. Jensen, what's your understanding of the purpose of today's hearing as far as a review?
I thought it was just the GAL review, I think, but I just wanted to state that I have seen pictures on social media of Megan drinking, and I've heard from other people that she was drinking and doing drugs. I did a hair follicle test. I was just going to ask the court, ask her to also do one.
What type of test did you say?
A hair follicle test.
Hair follicle. Okay. All right. And so kind of ask the same question, Ms. Holder. You can address any of those issues that Mr. Jensen brought up, but just as far as your understanding of the purpose of today's hearing.
In reviewing the court files, Your Honor, I'm not exactly sure what the purpose of this hearing is. It looks like the last one, there was a continuance requested for my client due to a sick child. Mr. Jensen also requested a set over to discuss further issues, but then he didn't file anything or put anything in front of the court for Ms. Rose to respond to. So my understanding is that there is still a GAL report that needs to be done, and that is due to be completed in June. So I'm not sure, based on the last hearing, which I believe was April 24th, I think that was maybe an interim GAL review, which is pretty standard, and then the full review would be done on June. So again, I'm not exactly sure what this hearing is for related to setting over to discuss further issues.
Yeah. Okay, thanks. Anything to add to that, Mr. Jensen?
No, Your Honor, just the hair follicle test. And previously we had found out that she was dating a convicted child pedophile. And I have gotten people have notified me that his machinery is still up at her house. She said that they had broken up. So that's kind of a concern for me, is if this man is still around my child and her older daughter. And
so Your Honor, I'm going to object. I know that these are the further issues, but Ms. Rhodes doesn't have the opportunity, has not had the opportunity to rebut those in a proper response.
Yeah, I think, those are some things that had been mentioned before about the breakup and the like. And so double checking with Mr. Jensen, have you communicated that information to Mr. Lawrence?
I have talked to Mr. Lawrence about that. He hasn't got back to me yet. And then I have asked him multiple times about, because he said the hair follicle tests are voluntary, but he also kind of told me that if I hadn't done mine, it would be a longer process for me to see my daughter. So it's kind of weird to me that I was required to do it, but Megan has custody of the child and she doesn't have to do it if she says that she doesn't want to. So
I get you. I hear you. Okay. So as far as today's hearing, yeah, I'm a little bit, I'm the one that set the hearing. I'm a little bit confused myself of what our purpose was here today. And I appreciate the input from both parties. I guess more than anything, I just wanted to make sure that things were going okay with the visits. And I haven't heard anything to the contrary, so I'm assuming that they're going fine.
yeah, sure.
And then there's a new request today that Mr. Jensen raises related to a hair follicle test. Generally, as you've heard me here say a couple of times, maybe today or before, just the notice and opportunity to be heard. So you're making a request of a hair follicle test, and then Ms. Holder's hearing that for the first time now. So the sense is that she would probably like to respond to that, and then we could have a hearing on that once she's had an opportunity Ms. Holder's had an opportunity to confer with their client. And I see that Mr. Lawrence is here. Mr. Lawrence, maybe you can share a little more light on with your input and purpose of the hearing and some of the things we've been talking about.
Yes, Your Honor. We were scheduled for essentially a compliance hearing 2 weeks ago. Ms. Rhodes indicated that her child was ill and wanted to continue it. And so I had received information that Mr. Jensen and his girlfriend had completed voluntarily taking the hair follicle exams, because we had to ask for the alcohol test to be added on to the hair follicle. And the reason for that was that Miss Rhodes was considering allowing Mr. Jensen to have visitation with the child, but since he had met his girlfriend in inpatient rehabilitation, she had concerns as to what the status was. And so when I spoke to Mr. Jensen, I indicated that in order to try to alleviate the fears of Ms. Rhodes for visitation, at this point, we had no court order demanding him to complete a hair follicle. So therefore, I asked if he would be willing to do it voluntarily. And since his girlfriend is not a party to this proceeding, I asked that if she would do one voluntarily as well, which they both did, and they came back negative. Then I found out that Megan may very well be seen a convicted sex offender, a gentleman by the name of Pittman, John Pittman. And so I spoke to her about Mr. Pittman, and I had received a copy of his watch report through the Washington State Patrol showing the conviction, and I sent it to her, and she had indicated that he had told her that that had all been overturned, but there was no indication in the watch report that there was any appellate decision on that. And so she then provided me with a copy of a text message where she alleged that she had broken up with Mr. Pittman. Now I find out that there is, I'm not accusing anybody at this point, but I'm finding out that there are now new apps or programs where people can set up bogus text messages to try to pass them off as a real communication. So at this stage of the game, I still have a lot of investigation to do before my report is due on June the 26th. And I intend to do that. The court did allow Mr. Jensen to have visits with Nora, and I haven't heard how those visits have gone, but I have had communication with Beth Fellows, who was providing the professional supervision, and she indicated that he was doing extremely well during those visits. He always came well prepared. The interaction was of good quality between him and his daughter, and she just wanted me to know that he was doing very well on that. And the court at that point allowed him to then have unsupervised visits, and that's pretty much where we are right today.
Very helpful. Thank you. Appreciate that, Mr. Lawrence.
Your Honor, may I address just a few things about how those visits are going?
Sure.
My understanding is that it is a every other weekend visitation schedule. One has taken place, one is going to take place this weekend. My client tells me that things have gone well. There is just one thing that is troubling. The last time when the child was returned to her, she was wearing the exact same clothes that she was wearing at drop-off, and that she had very bad diaper rash. And we are planning to submit those as a submission photos to the court as sealed. So visitations are going well. We are just a little bit concerned as to how the daughter is doing, why she came back with such a bad diaper rash that took roughly 5 days to clear up. As far as Miss Rhodes and who she is dating, she is no longer with Mr. Pittman. It is true that the excavator equipment is still at her property because there's ongoing work where there is grading being done, and he's trying to wrap that up and get that finished because he had already begun work on the property, but they're no longer together.
All right, thanks. All right.
I would like to say on that diaper rash, she had specified in court that the baby was sick. So when I had received her, she did have a small diaper rash, but she had like diarrhea. So she had went to the bathroom multiple times, and like 6 times before noon on Friday. So I had gone butt paste for her, but the diaper rash was pretty bad from her going to the bathroom so many times. And the clothes that I returned her in were the clothes that Megan sent me in that were way too small. And why would I return her back in clothes that I had purchased when Megan sent me in those clothes?
Okay. All right. Thanks. Okay. So I think at this point, I really appreciate the input from everybody in the update. That's great. The issue as far as the hair follicle request, I think at this point, Mr. Jensen, it sounds like he voluntarily did that. His girlfriend voluntarily did that in goodwill, showing no issues, negative in all respects. And then if Ms. Rhodes, thanks, wants to do that on her own voluntary basis, she's free to do so. As far as if you want a court order for that, I would just request that you submit just a brief motion related to that, explain your rationale, why that'd be appropriate. So, and then we can note that up and hear that.
How would I find that paperwork to do?
A couple options. If you go to WashingtonLawHelp.org, that's one option. WashingtonLawHelp.
But what would what would the paperwork be?
It'd be a motion for a hair follicle test.
Okay.
And I don't think you're going to find like a specific form of an order. You might find just a general form of the order.
Yeah, this is kind of like the issue I've been having is I've been trying to, when I found out she was dating the pedophile, I was trying to get a petition for a restraining order. There's just so many different types.
Yeah, so I would just suggest looking at Washington Law Help. There's also the Clear hotline that you can call. If you just search Clear hotline, it'll pull right up, and you can talk to a licensed attorney if you meet certain income criteria, and then they can give you some advice and guidance.
All right, thank you.
Okay, so at this point, I don't think we have any additional hearing dates other than the June 26th date. And if there were to be noted up a motion for the hair follicle, we'd certainly hear that when you noted up.
All right. I was also, so every other week end is fine with me, but I was wondering if there's any time in the middle of the week that either me and Megan, I could FaceTime with Nora, or if I could get her like one day during the week, because 2 weeks going without seeing her is kind of a long time.
Certainly the parties are free to agree to something more than the order that the court has established. And so with Ms. Holder coming on board, that means you'd have to direct your communications to Ms. Holder, the attorney, to talk about any specific agreements as to additional, time, video visits or phone calls or what have you. So I'll just kind of leave it at that. And then
Okay, can I write down her name real quick? Or is there a way I could get her number from somebody? Text Megan, maybe she can text it to me, or?
Yeah, Ms. Holder.
Absolutely. My office phone number is 360. And what is your email address? And so we can also communicate that way.
I have a email address. I never check it. It's just full of spam. So I can make a new one just so we could communicate. Is that it? Is that right? I have a work email. It's CMW.
I would prefer you create a separate email address so that I'm not sending you things at work and have the risk of disruption. If you'll call my office, I will provide you with all my contact information.
Okay, thank you.
Okay.
Your Honor, may I ask that Mr. Jensen also send me an email with his new email address so that I'll have that as well?
Yes, sir. Yes, sir.
Do you have his email address?
I do have his email address. It's in my other email that I use.
Yeah, that'd be great. If you could just share that email with that, then they can communicate via email. That'll be very helpful, I think, in the process.
Yeah.
All right. So I think we're done for today. And if there's any other requests, then they could be noted up for motion. Otherwise, we'll see each other on June 26th for the final GAL report.
Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all. Appreciate it. All right. That concludes the docket. We'll go ahead and end the Zoom.